Next week, 10, 11.
Item 1.
You could have sent someone. Why have you come? Okay, you.
May I mention one matter, Your Lordship?
Yes.
Out of the list, Your Lordship.
What do you want?
I want to mention a matter, Your Lordship. 482 application filed for quashing of the charge order, my lord.
That's right. See, all the matters from the next week onwards, serially it will come. No
Well,
need to mention it. Give your memo, we'll see.
Grateful, Your Lordship.
Wherever it falls, it will be listed.
Grateful, my lord.
Item 1.
Yes.
Yes.
May I please your lordship?
Any mentioning? No. Okay. Okay. Yes.
This is a vigilance matter, my lord.
Vigilance custom not there,
Counsel
pass over.
not there.
Vigilance
Pass over.
Item 2.
Item 2, my lords, I pray for a short adjournment, my lords, because we have to verify whether at this stage, if it has come down to a commitment stage, so my lords, this whole application is infructuous. So my lords,
Okay.
I pray next week so that we can take appropriate instructions.
Let it be 30th. 30th or 31st.
30.
As my lords, please. Grateful, my lords.
Yes.
Item 4.
May I please your?
Yes.
This matter, your lordship, we have challenged the discharge application, rejection of our discharge application, your lordship.
Yes.
The prosecution, the public party has initiated in proceedings under section 276B of the Income Tax Act, your lordship.
What is that order passed in that
The order part is, your lordship.
984 of 2026? Yes, 1916, 2016. Sorry.
The impugned order is that.
No. You had earlier approached this court.
No, that is, your lordship, we had approached
At the cognizant stage, it was challenged, and this honorable court, my lord, didn't entertain that and directed.
Say that you raised all the questions
At the time
appropriate stage.
appropriate stage. Yes.
227.
Discharge petition before the court below.
And it is rejected now.
That is
My lord,
rejected.
that has been-
We have filed this. My lord,
Why are you unnecessarily delaying?
No, my lord, may I see. 276B is.
Hmm.
They say that if your lordship see the wording, your lordship, the failure to pay the tax within time, your lordship. In my case, what has happened, your lordship, I paid the tax, but not within time, but
That
deleted.
is the
Let me
crux.
finish. Let me finish. The language opening line, your lordship, that the failure to pay tax. I have not failed to pay tax.
Failure to pay tax in time.
in time.
No, my lord, may kindly see 276B. Kindly have a look on 276.
Just see the, give there. Have you reproduced? You have reproduced.
No, your lordship,
Take the. We checked which provision you said.
Income tax act, your lord, 276.
To income tax.
My lord.
Yes.
My lord,
1 minute. 276. Yes, 276.
my lord,
1 minute.
that is the failure to pay tax.
Failure
There's a-
to comply. 276. Yes.
I repeated previous, but I couldn't pay in time because of my, that's a financial crisis. I got a surface notice and all that.
Where, which provision you are reading? 276 Income Tax Act.
B, sir, capital B.
Capital B.
My lord.
Okay. Capital
That is
failure to pay tax. Yes, read it out.
Right.
If a person fails to pay to the credit of the central government, the tax deducted at the source by him as required by or under the provisions of so and so, the tax so and so, he shall be punished with rigorous imprisonment for a term which shall not be less than 3 months. Yes. What is the delay?
Delay, your lordship, as per their complaint, they have stated that it has to be filed by 31st of May 2011. It has been, so in the financial year, it was dated in 2010, your lordship. I deposited in
We filed for financial year
2010, your lordship, 10-11.
2010.
I deposited the tax in the year 2011 in December, your lordship. My lord.
Date of deposit?
Let deposit.
Deposit date.
Here, 28th of May,
28th
December
December
2011.
deposit. Achha, this position is not disputed.
No,
These
no,
facts are
this
not-
position is not
See,
disputed.
these are small technical.
My lord, these are technical, but this is supported by the Honorable Apex Court judgment. Lordship, I am relying on. Yes, yes. No, no, no. Let the
My
Lord.
lord, may I complete it?
This
It's-
position has
Okay, let him
already been
come-
made clear.
Let him complete.
My lord,
Hmm.
the petitioner is not an habitual offender.
No.
It is for the first time because the company went in loss. Surfacing notice was served on the company, and thereafter the company didn't do any business. And this tax TDS has been deducted from the because we have to pay the salary to the employee. Whatever the salary has been given, TDS has been deducted thereafter, but we deposited in time. There is a provision also. Your lordship, there is circular by the government, your lordship.
Yes.
If your lordship will mind like KC. What is that circular? It's the
Have
instruction
you
by the
filed
CM.
it? Have you filed it? No.
It is not filed, your lordship. The prosecution under section 276B, my lord, may kindly see, have a look, should not normally be proposed when the amount involved and the period of default is not substantial.
The
This
amount
amount
in
is only 2
default has
lakhs,
also
my
been
lord.
deposited in the meantime to the credit of the government. No such consideration will, of course, apply to the levy of interest 100,201. Interest.
There is
interest-
a provision also, my lord, may there is the calculate it also, if they demand that is the interest, then we can pay the interest. Unfortunately, we didn't pay because of because of these things, we couldn't calculate.
Okay, see, so the judgment now.
My lord, I am showing the judgment of the Honorable
My lord,
Apex Court. My
another
lord,
thing
payment of.
also, and there are other points also. There
Hmm.
another circular by the department, your lordship,
Hmm.
kindly see.
Show me the.
The lordship will see that
Yes.
offense under section six, failure to pay to the credit of the central government under this heading 1, your lordship.
Cases
it's
where
a amount is-
non-payment of tax deducted at the source of 25 lakhs. What is the amount?
The amount is 2 lakhs. And your lordship may kindly see, in an exceptional cases like habitual defaulter, based on particular facts and circumstances of the prosecution may initiate it. You see, if it is an habitual offender, your lordship, then I can understand. And there's a provision for interest on that also. If the 201A say that if we pay the interest also, then no.
Yes, sir. Now okay, you tell me which.
Lordship, kindly see the paragraph. I'm omitting paragraph 47
47.
to my lord friends, my lord submission. Lordship, kindly have a glance. Paragraph 47. That is the Apex Court judgment in Madhumilan syntax case.
Yes,
Kindly have a glance, my lord, to
this is Supreme Court, huh?
Supreme Court, my
Yeah.
lord, in Madhumilan syntax case.
47.
47.
We are
My
unable
lord,
to,
my
we are
lord
unable to
friends,
agree.
my lord, we are unable to agree.
Agree with the
Above view of the High Court, once the statute is required to pay tax and a stipulated period within such period is to be made. The payment must be made within that period. If the payment is not made within that period, there will be there is default, and an appropriate action can be taken under the Act. Interpretation of convents by the Land Council would also be provision relating to the prosecution negatory.
To the
My lord.
contention that this is regarding
Default,
76B.
default in payment, my lord. Default in
That's
payment of
right,
TDS. No, no,
but-
no. Next, I am coming. Next,
Yes.
lordship, kindly see paragraph 49. That my lord friend has, or your lordship kindly see as to the contention that the case
Which
is
para? Which para?
49,
49, yes.
my lord, that
Very
is subject matter of trial. My lord, what difficulty he has shown, that is subject, only
the
subject.
contention that the case is squarely covered by section 278 AA of
Yes.
the act, that no offence has been committed in view of the reasonable cause shown by the appellant. We may state that the question can be decided on the basis of the evidence and which should be adduced by the parties also. That's right, but
Yes, my lord. Another point, my lord, regarding payment of interest, that will not also waive out the right of the prosecution to prosecute the, my lord, defaultee.
no, you can prosecute, but
Proceed, my lord.
it will not preclude you from
Prosecute, my lord. Prosecute.
charging
My lord,
interest on that.
my lord, my lord. No, no,
Why don't
interest,
you-
his submission is, my lord, I have paid the
But this
interest or
judgment,
not.
this judgment of the Supreme Court has
Supreme
not taken note of these circulars.
Circulars, my lord, that I don't know, because my learned friend has supplied this just
These
now, and
circulars-
also incomplete. That is,
Circular takes.
I have to check it, my lord. The circular.
Okay, then
Subsequently also your lordship may.
No, he has supplied me one circular.
there are two circulars.
No, one circular he has given. So I have to check it.
Come on 12th.
12, yes.
Come on 12th.
12th.
I am prima facie. I am of the view that it should be quashed.
Lordship may pass any order. I don't
No,
stand
that's
on
right.
the
See,
way.
It is a delay.
Yes.
It is an isolated case on his part.
No,
He is not a habitual.
Lordship,
thing.
because
The
I will not
circular
stand.
says that you should be lenient
Yes.
and you charge interest on that.
No,
You
no.
charge interest. Why to prosecute someone?
No.
For
Charging
small
of
delay.
interest. Charging of interest is different. Payment of interest will not waive out the right of the, because there is specific
You
provision.
are absolutely correct.
Yes.
Technically, you are correct.
Yes.
But just forget the technicality. Just see the delays.
No, that is
On
your
May,
your lordship.
May you are supposed to pay.
Yes.
He had done it on December,
Hmm.
20th December. Okay. It is matter of 2 lakhs.
No, that is
And the
successive.
circular says it is beyond 25 lakhs. You can do it
No,
and charge interest.
that amount I have to check, because he has submitted the
So
circular.
that is the
just
reason
now.
I am giving you 12.
No,
You
no.
come with-
What
there
my
is a
learned
complaint.
friend is saying, he is not a regular defaulter. He is a regular defaulter, because from
You
the
show me if you are a regular
every-
defaulter, I will not.
yes, every month, my lord, every month upon deduction of tax, he has to pay by 7th of the next preceding month.
You show
but
if you are
he
showing
in-
you are a
yes,
habitual
I'll show,
defaulter,
I'll
then
show.
he doesn't have it.
Yes,
Is the case
I'll
which has been initiated by your lordship. Other points are
12th
also there.
12th
I'll-
I
I'll-
will speak. Keep this thing in this file. I try to be lenient in this. These
No,
are
no,
compoundable
my
offenses,
my
you
lord,
know.
obviously, because we
Unnecessary.
we are
This is
Unnecessary, you are clogging the system. You are not cutting hold of the people, those who have
no, my
I
lord,
paid it.
another
2 lakh,
part.
3 lakh unnecessary.
Another
That's
part,
it.
my lord,
That
is
was
this
good.
leniency will also lead to the, because this TDS amount, lordship kindly have another part of the deduction of
And
TDS.
you
Deduction-
know in these kind of prosecution,
Lots-
N block,
No,
N
lordship,
block, these are compounded. N block,
lordship kindly see, the
hundreds and 100 cases in one day.
deduction of TDS from the persons, those who are entitled, that has not been credited to their account, for that they are being handicapped to get it, my lord. Unless
Yes,
that
you
has
are-
been
you may be right,
deposited
but,
in time, that will not be credited to their account.
If a
And-
perpetual defaulter, they are not.
Habitual, yes,
He is not a perpetual defaulter.
I'll show.
Just
Lordship-
check it up if you can show.
No,
that
no,
he's a
madam.
perpetual.
We
Then
have
he's out.
every leniency to the, because the amount specified, if that is correct, that is the leniency, my lord. That is
Then we
because of
can-
the
we
leniency,
can-
my lord, the amount has been.
Complaint. I have annexed the complaint.
Department is not
It's a complaint
of any pleasure of proceeding.
Naturally,
because
for it
this is a hectic process.
it is an expensive proposition for them also
Yes,
to prosecute
Yes,
you. It's better that
More than the amount.
Even if you are paying interest also, we want to prosecute.
Right. you think of charging interest also
Yes, my lord.
in between.
I'll be.
And I'm putting it on 12th. If you can
Lordship,
charge some
keep it on-
interest, I'll ask them to deposit and finish it up.
Lordship may keep it on 13th. Because another provision is there. He may go for compounding of
13th
offense.
you come, no
No, no.
problem. Nobody
Another,
would be there here.
my lord.
Nobody would be here except you.
Oh, sorry, my lord.
Let it be 12th only.
Oh, 12.
Okay.
Ma'am.
And
Okay.
come with the instruction that
Yes,
what
ma'am.
is the
But
extent of
another
interest you
provision
can
is there.
pay.
Another compounding provision is there. My lord, he may approach the Principal Chief Commissioner of Income Tax.
482 has already filed same compounding application. Think that it is a compounding application.
Obliged.
Why super technicality? Let us less burden the court is better.
Obliged.
Yes.
Item 5,
Yes. Pass over.
item 6,
Yes.
Pass over, my lord, my senior.
Pass over.
item 7,
And may I please, Your Lordship?
Yes.
Here is the application was filed for 300, under section 311 of CRPC for
1 minute. The sir has come. Which matter ask?
32 item.
We can, if nobody is there, we can take it up. No, you, 32, call 32.
Yes.
item 32,
Is not, he has not brought my.
Okay. Then don't mind. Yes, silence. Yes. Don't mind them.
Well, this, I'm challenging a prosecution initiated on section 18 of the Mines Act.
Yes.
May I draw your lordship's kind attention to section 18,
My mindset.
Mines Act particular.
The other side is the Union of India. my lord.
If notice has to be issued, we will issue notice. If notice is not to be issued, then
Inspector of Mines.
yes. Section 8.
Section 8,
Yes.
duties and responsibility of owners, agent and manager. The owner and agent of every can each be responsible for making financial and other provisions and for taking such other steps as may be necessary for compliance with the provisions of this act and the regulation rules, bylaws and orders made thereunder.
8 is
Well, you will have to-
section 8 of what? Section 8 of mines and minerals.
Section 18.
18, okay. I'm
Am I-
sorry. I'm sorry. 1 minute, sir. 1 minute. Yes. Yes.
Well,
Sorry.
your lordship will kindly see
Hmm.
the wordings, the owner and the agents of every mine.
Hmm.
Well, then 3.
Yes.
If the carrying out of any instruction given under subsection 2 or given otherwise than through the manager under subsection results the contravention of the rules, bylaws and orders, every person giving such instructions and also be liable for the contravention. Subject to the then formula, subject to the provision of subsection 1, 2 and 3, the owner, agent and manager of every mine shall each be responsible to see that all operation is carried out. The allegation is, my lord,
Hmm.
a complaint was filed after a fatal accident occurred inside the mines. My lord. My lord, your lordship may kindly state that complaint petition I have annexed, my lord. Your lordship may kindly have a glance, my lord, to the
That is annexure 5
yes, madam.
at page 53.
Yes,
53.
Lord, your lordship, and intimation 58, your lordship may kindly.
58. Okay.
And intimation of fatal accident occurred on 11/4/2023 at Garjan Bahar Open Cast Project.
Yes.
Lordship, may
Yes, I
I draw your lordship's kind attention to the date 11/4.
that is 11/4/2023.
And that Garjan Bahar Open Cast Mines.
Right.
Then my lord, that so punishment is prescribed under 72 and section 73 of the Act.
7. Yes.
Of the-
Yes.
Then 79 prescribes the limitation for prosecution.
Hmm.
But now your lordship may kindly turn to section 79. my lord. May I draw your lordship's kind attention to section 79? Has your lordship got it?
I'm just getting. 79. Yes, read it up.
May we permitted to place?
Yes, yes.
No court shall take cognizance of any offence under this act unless complaints thereof has been made within 6 months from the date of which the offence is alleged to have been committed.
Offense is on April, 11th April
4, 2000.
23.
And your lordship will kindly come to page 64. The complaint
Complaint is
on 10, 2000.
19.
19. I think that will be 2020 because it cannot be prior to the भूल लिखित 19 साल किंतु that cannot be prior to the incident below. So incident having occurred on 11/4, that would be 23. Am I clear?
No, this is 23. It should be 23 only.
It should be 23 because the incident occurred on 23.
The October 23, you mean to say?
Yes.
October 23, April 23. It's beyond 6 months.
Beyond 6 months. Then another is that even assuming that the
That 65 is clear. Just see, 65 it says 23.
you know
65, page 65 if you see,
yes.
that is 23, October 23.
But so and the second is the first point is it is barred by limitation. Then the second point is that I am the general manager of 3 mines, Vasundhara mines as a whole. Colliery manager who is in charge of that Garjan Bahal open cast mines, he has also been arraigned as an accused. The wording
You
is-
have not come insofar as the other accused is concerned. You are Mr.
telling you not.
Kolle Bachiri.
Every mine, the manager of every mine is the word.
Yes,
So every mine means the colliery manager of that mine.
right.
He has already been arrested as an accused. That is not being challenged before your lordship. I am the general manager of the company.
You general manager of Mahanadi
Of
Coalfield.
Vasundhara
Vasundhara.
mines, which includes Vasundhara area, which includes this Garjan Bahal.
Okay. But in your cost title, you are not describing who are you. If you see page
Yes.
1 of your cost title
Yes.
in the petition, you don't disclose who are you. Sri Reddy 56 so and so working as a general manager, Vasundhara area, Mahanadi Coalfield Limited.
Paragraph 4, page 4, paragraph 2.
Yes.
That the petitioner is a citizen of India and at present working as the general manager for Vasundhara Iron area.
Mahanadi Coalfield.
That is specified. So,
Let us issue notice then. Let us issue notice.
further proceeding may be stayed.
I'll issue notice on the stay application.
Imprisonment, that's all.
Interim also I'll issue notice. I'll put it on next week 11th or 12th on hearing on interim application. Issue notice to the opposite party. Retainable within a week. Notice on the interim prayer as well to be heard on 12th. On 12th.
This point was raised before the trial court. What the trial court.
Apparently you have a case, then we will stay on that day.
What the trial court did not, I have not taken your verses to the improved order. He told trial court gives a finding that the delay can be condoned under section 468 of the Criminal Procedure Code. But when
No, it is a special statute. Where is the 460? Where from you are getting 460? It is a special statute.
Oh, like I need to say anything.
468 will not come in.
Much so.
That only one ground is enough for you to get.
Item 7.
Yes.
Granted that you have
No, this is our duty, sir, to respect all seniors.
Everything on.
And I think nobody will mind. Thank you, sir.
Well, may I please, Your Lordship, right?
Yes.
Here an application was filed under Section 311 of CRPC for
Yes.
recalling of witness for further examination. Here victim was examined. Here, offense-
311.
Yes, madam.
Who is this witness?
Witness victim herself. And here what has happened, my lord? The offense is under
He is PW?
PW2. And offense is under 363, 366. Our contention was that she was measured at the relevant point of time. And she went with the accused. Now examination was
Elopement.
But the point is here, my lord, Lanet Court refused my application on the ground that the victim should not be repeatedly called for further examination to ensure that the victim shall not be repeatedly under Section 33(5) of the POCSO Act, my lord. And
PW2 is the victim.
P2 is the victim, my lord. Here, my limited question, because law is fairly well stated. Before filing an application, I have to mention what are the questions I want to put to the victim.
Right.
Here, crux is here. The victim is, as per us, she was measured at the relevant point of time. But at the time evidence, she has stated she was 15 years age. But on date of evidence, she was 17 years of age. Now, my contention before the learned court below, since the lawyer who was conducting counsel was suffering on that day, he could not come. Though despite all this, evidence was taken. I wanted to ask 2-3 questions. Number one question, whether at the relevant point of time, his father was alive, but then subsequently at the time of trial, he was dead. And that was
For proving the age of a victim,
not only
you
that-
want to bring her to put things on her mouth to extract a
No,
answer that she is measured.
No, that is not the point, man. I'm not on that point. I'm on the other point. Because father had given the consent to the doctor to go with that boy. Why my
Maybe-
stepmother was there?
If she is minor, even the father has given, father can also be prosecuted.
My lord, well, kindly appreciate my humble submission for lordship with this. Here defense should be given adequate opportunity. What I want
Yes,
to
you are right, but at the
Unless-
same time you have to balance.
yes, man.
If she is a victim, see, the idea of the POCSO is that.
Yes, man. She should not be harassed. That I cannot.
Should
Because
not be
had
harassed.
there not been victim, the things could have been something different.
Yes.
Here is the victim. as
Ordinary witness, any
Yes,
other
ma'am.
witness, I will not see the file. I will just ask one opportunity.
My lord, here what is Section 311? I repeatedly try to find out is there any bar to examine the victim.
No, there is no
Some-
bar.
No bar.
There is no
But
bar.
my lord, here limited 3 questions. I will put not more than that. I can understand if I will make questions. It may jeopardize that entire trial will be frustrated. The statement may be varied. Then
What
I
are
will
the
be-
questionnaires have you
My lord,
discussed?
kindly have a glance to Annex 4.
Oh.
Limited questions I have only. My lord, if you also will have a glance to paragraph 2, it is not mentioned there. Second line, the advocate for the accused persons
One minute,
was
1 minute, 1 minute.
page, my lord, 20, my lord, running page 20.
At the hearing, the victim girl was present before the court on 12/4/23. On that day, the advocate of the accused,
Yes, my lord.
persons was suffering from
Fever.
fever. Yet to honor the court, he made cross-examination to the victim girl, but after obtaining the certificate copy, you better bring that lawyer to examine whether he was suffering from. He was suffering, but he went to the court,
No, he has not.
cross-examined.
He has
And
not.
today you are saying that he could not
No,
do it properly.
He made it cross. He made consent to victim girl, but after obtaining certificate copy deposit PW2, it is found that some important material evidence will kept near the victim. As he does not disclose the real fact of this case, and as he was not properly examined, that at the time of occurrence, the father of the victim was alive, but presently he has
Yes,
been
it-
died, and victim is well acquainted.
He has
What
to give
was-
evidence. And
What was her father's advice? Why she was fled away? But these are the questions, sir. Why she was unwillingly fled away, or as per the advice
See,
of her
these are
father?
leading questions. How can you say fled away or not?
Because my lord, here vital this is, my lord. Because if
You may be vital for
the
your defense, but
geopart-
can you say that have you fled away?
my lord, that question.
He'll say no.
He exactly my that
Then
answer will not change anything. But here anxiety is here. The defense should have given adequate opportunity. That is only small prayer I have before you also. In single day, it can be over. It is not any
You
further
can-
question they can have put.
I think you can lead the defense evidence, bringing your own evidence.
My lord, what is the stage of
Now,
trial?
the problem is that had it been a case of the other not governed by the special statute, then matter would have been different. It's a case where the special statute is there. Section 35, subsection 5 of the POCSO Act clearly says that a victim should not be harassed and should not be repeatedly called
That's
For
right.
example,
That's
that is the
may be
whole
the-
difficulties.
That is the only reason why the trial court has rejected.
Exactly. And then when the victim has been examined, cross-examined, then the question of recalling the said victim again.
Here,
That
victim will
case.
not be prejudiced. Nobody will be prejudiced. I repeated, she has not been called. She has been once examined. My lord, I admit I cannot deny the same. But here the questions have been framed. Had there not been no question, I am just asking, filing a petition, but lingering or frustrating the trial, the things could have been something different. Here, my limited prayer, certain question has to be put because the stepmother wanted to say, already sold one of her daughter. And that stepmother instances, she might have left the place, which cannot be concluded at present, without any.
What is the evidence came against you? Evidence has already came.
But I don't know what is the latest position because the trial has not been stalled. It was continued because I have
No,
not
what
got.
she might have in the examination chief, what has he said?
No, that is there. That I have annexed. That is annexed
She
to
might
my
have
list.
said, have you demolished that part?
A lot of allegations were there which could not be established at the time of investigation because POCSO is not there. POCSO Act is no more there, my lord. At the filing of charge sheet, POCSO is not there. Only 363, 366. And जबरदस्ती विवाह करे चेष्टा कले तो किडनैप करने किडनैप में मोटरसाइकिल हिचंती से गोटे जगह को जाइछि पैसा नहीं किछि एस्टैब्लिश हेइन सी जगह the POCSO Act ही लागी नहीं
17 years, huh?
Yes, my lord. 17 on the date of examination. My lord, kindly have a glance to her chief, my lord.
Yes.
She has stated that at the time of occurrence, she was 15 years old.
Yes, that I have seen it.
Yes, my lord.
Page 16.
Yes, my lord. My lord. Thereafter, my lord, everything she has narrated, even she has narrated regarding rape also. Though there is no 376. There is no POCSO provision. Though no offense under the provisions of POCSO, my lord. Nothing is there. I can understand, had it been case absolutely under section under the provision of POCSO, yes, the matter has been referred to POCSO court and that is matter special court is matter sub judice. Had it not been so, my lord, I could not have approved before this honorable court, my lord. And the charge sheet was for 363, 366.
Last we kindly turn to page 17 cross-examination.
Yes.
Para 4.
I do not know.
Yes, from there, clearly, my lord, she has been cross-examined briefly. You'll also may kindly turn to, it is extended to para 7. Up to para 7.
Most important, my lord. Para 7, I'm just reading. I sat in the bike of my own when Subodha took me by that motorcycle. That time I knew that I was a minor. I went by his bike for the purpose of marriage with accused Subodha. This part is clear. Now, it is not fact that as I had loved relationship, if she had no love relationship, she went with another stranger without any basis, my lord, and took money with her. That is the allegation which has not been established. And my lord, at this juncture, unless my lord, I will be given an
I think you have other option to prove that she's.
Is there any law, my lord, where there is no relation, somebody will not accommodate with another person? It's astonishing. Is there any law?
The kidnapping. The kidnapping is a
This is not absolutely not a relevant question.
363, she will be attracted here, my lord.
Only the paragraph 2
small
of
glance,
page
my lord.
10, it's not relevant. Paragraph, page 10, paragraph 2. My lord, I'm reading. It is stated that PW2 is
Paragraph?
paragraph 2, page 10, where the landed trial court has
Rejection
observed.
order, my lord.
Okay.
But it is stated that PW2 is the victim on the date of hearing, that is on 12/4/2023, the victim was cross-examined, but the advocate of the accused was suffering from fever. The victim did not disclose the real fact of the case. It is further stated that the father of the victim was alive at the time of occurrence, who was died in the meantime. It could not be ascertained whether the victim willingly fled away or she fled away as per her advice of her father. It is also not known whether the informant is the real mother
Call the
or
father.
stepmother. Well, can it be?
Father is no.
Is it relevant? Well, is it relevant?
Mother
to the
is
case?
cited. Mother is cited as a witness.
Must be, my lord, because she is the
See,
informant.
there are other witnesses. You can not don't harass this girl. Don't harass this. Write down. The petitioner is facing trial in the where is that affair? Facing trial. Yes, facing trial for allegedly for having committed offence under section 363 and 366A for IPC. IPC. The victim girl was examined by the trial court as PW2. Full stop. She was subjected to cross-examination. PW2 on date लिख देना on what is this date here
That is at the top.
or the top on
It is
such
on
and such
12th
on such
April.
and such day, and she was subjected to cross-examination on whatever.
Also later.
Next one. Date is on. Full stop. The petitioner moved an application under section 311 CRPC seeking recall of the said witness for further cross-examination. The sole ground on the basis of which the application under section 311 CRPC was moved is that the victim PW2 could not be appropriately cross-examined because on that day the counsel for the defense counsel was suffering from fever. It is not the case of the petitioner accused that the PW2 was not the case of the petitioner that no opportunity was afforded to the accused for cross-examining the witness. Nor it is the case that the defense counsel could not cross-examine the witness. It is only stated that after obtaining the certified copy of the evidence, the defense counsel realized that there are certain crucial questions we ought to have been put to the witness. The trial court rejected the prayer of the defense counsel, prayer of the accused petitioner seeking recall of the witness by the impugn order dated 4/7/2023. The trial court relied upon section 33 clause 33 subclause 5, 33 bracket 5 of POCSO Act to say that the courts, the special court shall ensure that the child is not repeatedly called for testifying in the court, which would tantamount to harassing the victim. Also, this court is completely in agreement with the trial court. Having said that, the defense is defense has enough opportunity to cross-examine other prosecution witnesses and also to lead his own evidence in defense. Also, I have perused the questionnaires, proposed questions to be put to the PW2, which is reflecting in the application under section 311 CRPC. The said questions and the expected answer by the defense could also be elucidated from the other witnesses. Hence, the application under section 311 CRPC seeking recall of PW2, the victim girl, deserves no merit. Hence, the trial court has rightly rejected the same. Next paragraph. Accordingly, the present petition is disposed. Next. Next.
My lord, I don't see the also permit. If so advised, the defense can adduce this personal evidence.
I have written that.
That is
I have written that you can lead defense evidence also.
much obliged.
That I can. In any case, after 313, you have a right that. But I've tried
Yes,
to
my lord,
protect that to that extent.
Obliged, man.
Item
Yes.
8.
Yes.
May I please? And in this application, there is petitioner. And this application for quashing of present petitioner have filed the application for quashing of criminal proceeding.
Okay.
In the meantime, the matter has been settled between the
Parties.
and present petitioners.
Petitioner and
Petitioner and the informant.
informant is
Matter.
two.
This matter.
What is the offense?
Offense 294, 506, 34 IPC and on the section 3 of SC and ST Act.
Huh?
3 of SC and ST Act. Here, the present,
Is there any bar in SC
No.
Act?
no,
There is no bar.
With the consent of
Where-
the,
Where is the opposite party number 2?
my brother is there.
Joint
Allow us to file joint affidavit regarding the same person.
you file it. You file it, I'll put it on 9th or 10th. The
In
the
the meantime, NBW has been issued against the present petitioner.
okay, we'll say that.
Yeah.
The present petition, by way of the present petition, petitioner seeks quashing of the cognizance order dated 9/5/2018 passed by the Learned Sessions at Sambalpur in special GR case number 2 of 2018. Full stop. The counsel for the petitioner says that submits that they have arrived at a out of court settlement with he has arrived at. Itne mein kyun two. They have arrived at a out of court settlement with the opposite party number 2, who is the informant in the case. Mr. Sumanta Kumar Pradhan, Sushant Kumar Pradhan has entered appearance on behalf of opposite party number 2 and filed wakalatnama. And states that indeed they have settled the dispute out of court. Both the petitioner and opposite party number 2 needs to file a joint affidavit. Enumerating therein the settlement. Full stop. The petitioner further submits that in the meanwhile, non-bailable warrant has been issued against his client by the learned trial court. Next paragraph. Regard being head to the fact that the parties have settled their dispute, the operation of the NBW order.
Answer for
The operation of
12/23.
operation of order
In
dated,
IA number 15 of 24.
which is the order?
Order dated 4/12/23. Answer 5 million. In IA I have
Yes. Operation of order dated 4/12/2023 is stayed till the next date of hearing. The matter is now to come up on 10th.
My pardon, my lord. In this case, my power is there, my lord. So, in petitioner number 1, who is succumb brain stroke, unable to walk and move, my lord, and unable to speak in this case, my lord.
Sorry?
Petition number one.
In this case,
Ah,
my
He su-
petition
he
number.
suffered from brain stroke, my lord. Therefore, now he is unable to move from anywhere.
Okay, okay.
That's
He is
why.
appealing
Unable
for
to
it.
speak. No, my lord, my power is also with my lord and the senior
Are
power.
you appearing for him or not?
Joint power.
Joint power is there, my lord, for petitioner.
Joint power. It's all right. Okay.
So on behalf of petition number 1, petition number 2, my lord, who filed the joint affidavit on
Yes,
this
yes.
ground, my
Okay.
obliged.
Yes.
Item 9.
Here, my lord, the petitioner has challenged the initiation of the proceeding, which has been registered for the offense under section 363 of the Indian Penal Code. The short point, the petitioners are husband and wife. Petitioner number 2 is the victim, as per the allegations made in the affair. They have married in the meantime, and annexure 2 is the marriage certificate issued by their authorities, my lord. Question comes up here.
What is it?
As per the allegation made in the first information report, the victim is 15 years old. Whether the Muslim law provides that Muslim girl attaining age of 15 years, whether its marriage is permissible or not. That's the question. But I was going through Ullah's Muslim law. They say that who may contract a marriage as per Article 156. Every Mohammedan or sound family who has attained puberty may enter into a contract marriage. Puberty is presumed to be in the absence of evidence on completion of 15 years. That is the only point. If my lord will accept that
POXO is not.
if POXO is not there, that is the question which I have also raised. If they have not raised, they were quite aware of the fact that Muslim girl 15 years, so POXO is not applicable. POXO has not been registered.
POXO charge is not there.
It's not there.
I don't have any
FAir copy is there, na?
FAir copy is there. 363 it has been registered. But in the course of
He's
investigation,
15 years.
yes, whether it has been turned to POXO or
Marriage
any other
certificate
things,
also
I
active.
don't know.
They have also accept marriage certificate is annexed.
There is Nikanama is already there.
That's true, my lord.
Just see Nikanama. If there is a Nikanama, there is an admission that they have married.
Correct.
15 years. No POXO.
No POXO.
The question is, my lord, the affair,
In the absence of POXO, we can pass.
my lord,
You have
here,
not invoked POXO, what to do?
here is the affair has been registered on section 363 on the allegation that somebody has kidnapped a minor girl.
Minor girl to hell
So-
POXO.
So at the same time, affair, it's not required to be registered under section 363 and POXO Act.
Oh.
There is no law, my lord. Subsequently, during course of investigation, the calculation of the age will be taken into consideration. Verbally allegation of the
There must be some consequence, otherwise you
Nahi,
can
nahi.
Yes,
Item 10.
yes.
My lord, my petition 205 was rejected by the London magistrate.
200?
5.
Yes.
Petition annexure 3, page 70 is the improving order. The petitioner is an advocate. Apart from this, my lord,
What is the offense?
offense, my lord, 420, 468, 471. It is based on civil dispute.
Which court is this?
We, my lord, JMFC,
Bhubaneswar.
taken Bhubaneswar.
You are stationed where?
I am in Bhubaneswar, my lord.
So what is the problem? Why can't you go every time you are moving the 5?
My lord,
205.
admitted your lordship may go. At any stage, the magistrate may insisted me.
That apart, merely because you are a lawyer, you want 205 exemption,
No, my
and
lord.
you are in Bhubaneswar, practicing in Bhubaneswar. Case is also in Bhubaneswar.
My lord, 3 things. Records that, my lord, I have gone through the records. It is shows that he is an advocate first.
He
Second,
must be feeling insulted to appear
My lord.
as a accused.
he is doing business of also. So, no, it is not shown in the.
Then why do you say that he is a
My
lawyer?
lord, I'm saying that
He is a real estate. He is a real estate.
simultaneously, my lord, he is ill. So the London magistrate observed that
If
You
are
first
in
tell
a
whether he is a lawyer or he is a
lawyer,
property
he is
dealer.
a lawyer. And annexed your lordship fair. Four.
Lawyer having committed this kind of offense, feeling insulted to appear in the court.
My lord, case of
समझ
2005.
हाँ.
My lord, 2005. I have
Therefore,
captured
205.
it. Your lordship may kindly visualize. The complaint case shows that 17 years back incident.
Now, what prevented you to appear? You tell me. What is your age?
My age is 45 years.
45 years.
Fair.
Then
Your lordship.
205 is meant for you like people?
My lord. My lord. My lord. There is also decision in the Damodar case practicing.
If this kind of
A
applications
businessman.
are allowed, we are
My
doing disservice to the system.
Businessman.
Rejected.
My lord, your lordship reject.
Rejected. Age and when required, you go and appear. We are, you are supposed to be a lawyer more responsible than anyone else. Yes. Right? Yes.
May it please.
11?
11 minutes.
Yes.
Because the informant before my lords is one Srimati Sanjukta Pradhan, who had earlier lodged an FIR against one Akshay Naik and one Abhamay Naik under punishable for offences punishable under section 498A and 494 of IPC, my lords. That particular case had come before this honorable court in another CRLMC, wherein Akshay Kumar Naik, who was accused of offences punishable under 494, had filed that particular CRMC. His case had been dismissed, my lords. And after that,
in the same FIR.
In the same FIR, my lords. The present case is another complaint case, which, my lords, which I'll come to. Now, that particular CRMC which was dismissed, that was challenged before the Honorable Supreme Court.
Yes.
That learned Honorable Supreme Court is in session of the matter, my lords, in which notice has been issued. I'm passing the order. Now the allegation, now the three petitioners before my lords who are in the complaint case, they are three witnesses of an alleged second marriage of that person, Akshay Kumar Naik, my lords. The copy of the marriage certificate is at page 41, my lords.
Page 41.
Page 41, my lords.
Yes.
Now, in the present case, the allegations of 498A are against those three witnesses, my lords, who are witness to the second marriage.
No, you tell me just this Kishore Akshay Kumar Naik is one of the co-accused with this.
Is one of the co-accused, my lords. But he is not before my lords in the present petitioner.
That's right. But in the same FIR, he is one of the accused. Where
one of the accused, my lords.
Right now. The land counsel for the petitioner submits that one of the co-accused person had earlier approached this court by filing CRLMC number 2329 of 2021. The coordinate bench, while its order dated 2/2/2023, has been pleased to dismiss the.
It's a case like this, madam. Earlier case was a police case.
I'm not saying anything. I'm not.
No, madam, there should not be any confusion of the order also. Earlier case was a police case where Akshay Naik with the alleged husband, he has challenged the order of taking cognizance that was disposed of by this honorable court. Against that order, SLP has been filed. TRLP has been filed. Now here, this case arising out of a complaint petition. Another case.
Why are you saying this accused in the same FIR?
No.
No, same na.
He is a co-accused.
Like 210 of section 2. There the case is there. Here also he has been taken as an accused. This Akshay Naik has also been taken as an accused. But in a different case.
What I am trying to say is let him place it on record. I just check it up whether connection, because something is pending in Supreme Court. Why should
yes.
preemptory order? Anything may happen then. What is? Dismiss the said petition. Thereafter, the said accused filed SLP criminal D number 18666 of 2023 before the Supreme Court of India. Full stop. The Land Council for the petitioner hands up a proceeding dated 6/10/2023 of the Supreme Court of India, which indicates that the matter is sub judice. Let the counsel for the petitioner place on record the order and please order and disclose the details of the cases pending either in Supreme Court or any other court regarding this, regarding the FIR sought to be quashed in this proceeding. Place on record everything. Next week, we'll give it
Lots is issuing notice.
20 seconds.
Lots is issuing notice.
No, you place it on record, then I'll issue notice.
And you also may kindly kindly direct this matter be taken up along with it, along with CRLMC 2329 of 2021.
Lease the matter along with the CRLMC
2329 of 2021.
Okay. You place that.
This is the present
And you be sure what you are saying, you are not sure. You now at least you got confused. Either because of me or because of you are learned senior. But you are not confident, therefore you are getting confused. Be confident. Read it and be confident. Okay.
Item 12.
Yes.
May I please, Your Lordship?
Yes.
Last date, Your Lordship has been given direction to deposit the cross-examination of PW1. I have already deposited my lord through memo, my lord. It is a...
Well, just now I have received the copies my friend has given me.
Yes.
Next week?
Yes.
Next week.
My lord, may I pray one thing? My lord, tomorrow it is the date of...
You seek adjournment, it is pending. We are putting
my
it.
lord, on previous date also there is...
No problem. You can...
Hello.
Is recalling the witness, na?
Again.
Which witness, by the way?
My lord, PW1, who is the informant, my lord.
What is the offense?
My lord, 302.
Informant is the how is related to the deceased?
My lord, he is the daughter of the deceased, and accused is the father of the informant.
Do you have any problem giving one opportunity?
You also may kindly turn to page 31.
30?
31.
Yes.
But may I read from Perus? We start the word Perus.
Perus the case record, yes.
Perus the case record on 23/8/2022. Sajna Mukhi was examined on that day. Cross-examination of the witness was deferred to 1/9/2022 due to want of time. On 1/9/2022, as the PO was on seal, the record was posted to 14/9/2022 for cross-examination. On that day, Sanjana Mukhi was present and was tendered to cross-examine, but as the learned advocate for the accused was found absent, the witness was discharged. Again, the learned advocate for the accused filed one petition on 9/5/2023 with a prayer to recall PW1 for cross-examination. Said petitions were heard and allowed, my lord. This is important. Subject to payment of cost ₹1,000, and on 10/5/2023, and according to the learned advocate for the accused, deposit ₹1,000 on 2/6/2023. On 5/8/2023, the witness was cross-examined. After depositing the payment, and again she was recalled, and she came, she deposed, she was cross-examined. Then again another application was filed for cross-examination, recalling the said witnesses.
On the same day, on the petition.
How many times the said particular witness will come and depose and cross-examine? First he was came, examined, cross-examined, then...
May I press? My lord, for that reason, my lord, your lordship has been directed to deposit the cross-examination of the PW1. My lord, I have filed the memo, my lord.
Nahin,
My lord,
why
kindly have
why I did is to know that this witness has been turned hostile, and a
Yes, ma'am.
prosecution witness turned hostile,
My lord.
and you want to re-examine the
My
hostile
lord.
witness.
My lord.
So I wanted to know
My lord,
if
that is the reason, my lord. Therefore,
a
on
witness
last
is
date, my
hostile,
lord-
why are you bargaining that risk of bringing him once again? That's what
My
I
lord.
was wondering.
Yes.
So
That
that
is
is
my-
why I wanted to see
Yes, my lord.
what is the cross-examination.
Yes, my lord. That is, my lord. Kindly have a glance on paragraph 7 of the cross.
But how will you get over this? The para which he has read.
Yes.
You
That is-
were absent. Witness was discharged. You moved an application. Application was allowed subject to 1,000 rupees cost.
Right.
Cost was paid. Cross-examination is afforded, and you cross-examine.
No, my.
Yes.
I am not cross-examining. The prosecution has.
That
been
is what is the order is. How can I?
My lord, therefore, my lord, I have produced a cross-examination of the PW1. My lord, kindly have a glance on the cross-examination of the PW1.
It says on 9/5/2023 with the prayer to recall PW1 cross-examination. The said petition was heard
lord.
and allowed subject to payment of cost of 1,000
Yes.
on 10/5/2023. Accordingly, the learned advocate for the accused deposited 1,000 rupees on 2/6/2023. On 5/8/2023, the witness was cross-examined.
Yes.
Yes, my lord. I have not.
Thereafter, again you are.
No, my lord. I have not cross-examined. My lord, the prosecution has been declared as a hostile witness on 5th August 2023.
The prosecution
And my
has
lord,
crossed.
Yes, my lord. Prosecution has cross-examined the witness. I have not cross-examination because my lord, the prosecution has filed the application of that under section 137 of Evidence Act on 5th August 2023 and served the copy to me on 8th August 2023. Before that period, the witness has been declared as the hostile witness. Therefore, my lord, I am unable to ask only one question also because, my lord, it is an allegation in paragraph 7 there. Whatever I have stated today was as per the say of the advocate of my father, who is the accused advocate.
Where is the cross-examination?
Yes, my lord, that is the paragraph 7, my lord. In
Where is
memo,
that?
my lord, I have filed in page number 3 of cross-examination.
Where is that, ma'am? Do not scan it. Yes, I think that's there. It is cross-examination as a 5/8/2023.
Fine.
Okay, come. Where do you say that it is the cross-examined by the prosecution?
Yes, my lord. That is, my lord, kindly have the entire cross-examination of the 5th August 2023, my lord. Kindly have a glance.
Read it. Para 3.
My lord, that is the, my lord, para 3 is I am doing nothing, my lord. I have read up to +2 hours. I have not passed +2 hours.
Who has cross-examined this?
My lord, this is the prosecution, my
Where
lord.
from I'll get it?
That is, my lord.
Just see
My lord,
after 6, question number 6.
my lord, kindly have a
After you cross-examined, and thereafter after question number 6, she was declared hostile. Just see. Why are you making statement like this? Then 137 was invoked with 154. Just see, question number 6. Just see. I know Sunita Mukhi, and who is not pulling one well with our family. It
Yes,
is
ma'am.
not a fact that the police has taken my signature on false and registered a false case against me.
against my
At this stage, learned additional PP, file a petition under 137
Seven.
and 154, declare hostile, cross-examine. Then your statement is absolutely wrong. And by way of cross-examination, the PP only put one question. That is question number 7.
Yes.
My lord, may I?
Then how will you find fault with the
my lord,
order, impugn order at
my lord,
para 7 which he read?
My lord, may I Can you have a glance on the order dated
Yes.
5/8/2023, my lord?
Come on.
That is in memo,
Yes.
in order
Five-
sheet,
5/8.
2023, my lord. That is in memo.
Come on. 5/8. I got the weeks. What are 5/8?
Cross evidence.
That
And
is
proceeding. 5/8.
2023, my lord.
5/8.
UTP is produced through BC.
Yes. 5/8.
Lawrence- Lawrence Council for the accused files Hazira.
5/8. Yeah. 1 minute. Yes. UTP is produced through VC. Let the counsel for the accused file Hajira.
Witness name
Witness name is so
is
present.
cross-examined
Is
and
cross-examined and discharged. No
other
other.
CWS issue someone to the IO for trial.
Yes.
My lord.
This is again correct. Cross-examined, rightly cross-examined by you as well as the prosecutor.
Yes, my lord. After, my lord, that declaring of hostile witness, my lord, I want to ask some questions, my lord. Therefore, my lord, I have put that petition, my lord. And my lord, the hostile petition has been served on me on 8th August, my lord. But the witness has been declared on 5th August, my lord. Kind have a glance on the page number.
This is PW.
Annexure
Which
3, my
PW?
lord. Page number 25, my lord. Kindly have a glance. Page number 25, Annexure 3, my lord.
Yes.
My lord, the left side, my lord. Received with objection on 8th August 2023, my lord. My lord, before giving me copy of the hostile witness, the hostile witness has been declared. The witness has been declared the hostile witness.
During the course of cross-examination, this has happened. Your fifth and sixth question led the prosecutor to declare the witness hostile.
My lord.
It is because your questions.
Yes, my lord.
Okay. And that goes to show that the witness was appropriately grilled by you as well as the prosecutor.
But my lord, after cross-examination,
Then where is the question of recall?
My lord, after the cross-examination, the prosecution, we want some questions only regarding the investigation of the case.
See, defense counsel keep on getting wiser day by day, then you can't keep on asking the
Only,
witness
my
to
lord,
come.
Only, my lord, one chance, my lord, for fair trial.
If
my
he
lord,
doesn't
is
object, if he doesn't object, but
my
the
lord, it is a
prosecutor
case
objects,
of-
I can't help it.
My lord, it is a case
It
of
is again
three-
again a question of grace by the prosecutor.
It is a, my lord, case of 302, my lord.
What are the questions?
My lord, in page number 28, my lord.
28. Yes. 28. Read it out.
Yes, my lord. What was the last date or day you have met your father in Bhubaneswar? How many times you have visited your father in jail and one? How many times your father sent you money and what may be the total amount? He transferred money to you directly or through any other person, either mode of PhonePe or money order. Can you say their name? When you come to Bhubaneswar of your residence,
What is the age of this witness?
Yes, witnesses.
my lord, that is
सीता नहीं.
You see?
First से दो terms ना है किसी
Cross-examination.
No.
His examination chief is also not there.
my lord, that is 21 years.
Where from you got it?
My lord, page number 8, complainant 6, Sanjana Mukhi, date of year of birth 2022. Annexure 1.
तो ये fair है.
In charge sheet, the age has not been mentioned.
এটা 20
In page number 1.
23 26 છે.
2022.
नहीं 22 ହେଇଥିଲା ତାକୁ 22.
2002 ରେ date of
ହଁ ଠିକ है.
21.
What do you say?
I have read out the entire things, my lord. The witness has already recalled. It is again a petition file to recall the.
No, he
same
doesn't
witness
have a
again.
he doesn't have a case, but what is running in my mind is it is a case of 302. if one singular opportunity is given, if he can get some benefit.
Your Lordship, please.
Because the questionnaires, just see the questionnaire at page 28.
I have seen, my lord, I think, my lord, this is not relevant. Even thereafter, your Lordship may suggest whatever your Lordship wants to pass.
How many questions?
Madam, there are 29 questions.
29. Which are not absolutely not relevant.
Absolutely, you are.
It's a
You
case
are
of
trying to,
302. It's a case of 302. These questions are, I think, absolutely not relevant. Let him to place how it is relevant to the prosecution case. Which question, exactly which question is very relevant? Subject to correction of my Lordship.
Can we do one thing? We can
Yes.
put this thing to the trial court to examine the relevancy of this question, then.
Yes. Absolutely right.
If
Absolutely.
they are not relevant,
Yes.
then the witness will not be called.
Yes. Absolutely right. Your Lordship may dispose of on that line.
Okay, we'll try to do that.
Yes.
Huh? We'll try to do that. Look. When was this witness examined first? The
First examined?
chief examiner? That is, I think, on 14/9/2022.
29/2023.
The
What is it?
petitioner is facing trial for allegedly committing offense under section 302 IPC. IPC.
First is the chief. First the data.
After the charge sheet was filed in this case.
First date, my lord, 23/8/2020.
First,
First.
the trial was set in motion against the petitioner, and the witnesses, prosecution witnesses, have been examined. This case, this petition is pertaining to the recall of PW.
PW1.
Recall of the first prosecution witness, that is PW2 or PW2 Srimati or MS
Sajana
Mukhi, who is the informant in this case. Cool, sir. The witness, the said witness was examined on first
23rd August 2022.
23rd August 2022. And was subjected to cross-examination.
Yes.
It appears from the record that the accused, the petitioner, the defense counsel was absent when the witness was present to subject herself to cross-examination. Therefore, the trial court discharged the witness. On application, the witness was recalled, subject to payment of cost of 1,000. The petitioner paid the cost of 1,000 on 2/6/2023 and subjected the witness to cross-examine on 5/8/2023.
Yes.
However, on that day, the said witness turned hostile. So, sir, it is the case of the defense that since the witness had turned hostile, the relevant questions, the defense counsel missed to put relevant questions to the said witness. Therefore, he has moved this application under 311 CRPC. The learned trial court rejected the application on the ground that repeated opportunities were afforded to the defense counsel for cross-examination. The counsel for the petitioner placed on record, where is that, page 28, where is that?
Well, that is page number 28.
Counsel for the petitioner placed on record the application under section 311 CRPC, wherein he has enumerated the proposed questions.
Yes.
As many as 29 proposed questions to be put to the witness. Next, learned state counsel opposed the application to say that all those questions are completely irrelevant. So recalling the witness for putting these questions is a futile exercise. Next one. I am of the considered view that the petitioner is facing a serious charge under section 302, a free and fair trial affording sufficient opportunity to the petitioner being an accused is necessary under the law. Therefore, it would be appropriate if the trial court examine all these 29 proposed questions to be put to the witness and take a call as to whether the questions are relevant or not. Accordingly, the trial court may afford a singular opportunity to the defense for recalling the witness for re-examination. The cause for recalling the said witness for re-examination is subject to the relevancy of these questions to be determined by the trial.
Right.
Petitioner is disposed of accordingly. It is accordingly directed and petitioner. He will examine.
Well,
if it is relevant, he will call, otherwise he will not. That singular opportunity.
Fine.
Yes. 13. Yes.
Or see new look. At first I could not recognize.
I thought you are following me.
I was following you.
Then you will
after
now also you
seeing-
follow me now.
My daughter will also not recognize me.
It is always better to have change. Yes.
My lord, I have here, my lord, challenged the rejection of the 205 application in a, my lord, ED case. I have come before your lordship. This case is, my lord,
what is the offense?
The offense, my lord, the
PMLA.
PMLA. They
Section
complain,
3
they
read
filed
with
complaint.
Section 3 read with 4 of the
My-
PML Act.
PMLA. They filed complaint in the year 2018 against many accused.
No, why 205?
But they, my lord, I am staying at Cuttack. I am a businessman, man.
Where is the case going on?
Bhubaneswar, my lord.
Cuttack Bhubaneswar is very near.
Yes, no, that is not disputed, my lord. But I am not well. I have been going through many ailments.
What is
and
your
I'm-
age? What is your age?
My lord, age is about, my lord, 53.
53 is not.
53, that is not the ground, my lord, here. Here, my lord, they have never arrested me. They have never arrested me. First time someone was issued, I filed an application under section 205.
You are very lucky then. They are not arrested you.
And now the schedule offense.
Since you are so lucky, you are not arrested. At least go and have the grace of appearing before them and
No, I
explain,
want the
explain
schedule offense,
PMLA.
not the schedule offense for.
Without appearing, how will you explain?
No, my lord, 205 can be, my lord, without appearing, it is done without appearance. On the advocate appearance, and I have got the, your lordship, that remember.
You have video conferencing.
Yes.
Lord,
Yes,
you
yes.
have video conferencing.
Yes, my lord.
Special court has video conferencing, but here, my lord, similar question was raised under the PML Act before this court. The lordship kindly.
No, what I am proposing is, I will not go there. What I am proposing is, He will appear video conferencing.
Lord,
As and when required
he-
physical appearance. will
That's
be
true,
insisted,
Lord.
that's all.
But
That's
he
all,
must
my
go and take bail first. He has
You have
even-
to, I am not deciding bail
No,
application.
no, if once your lordship will direct this, he will not appear and he will not apply for bail. Anyway, he used to go and take bail.
That he has to do.
That
he has
he
no
has to do.
escape.
That is the sole question.
No,
Yeah.
bail, my lord, the concept of bail.
This is
Because
not a
to
bail court.
avoid
Yes.
bail, my lord, this
No, no,
practice
no,
has
no,
been
no, no.
taken. Your lordship kindly note, he
I will
appeared.
clarify that, don't worry.
Yes, yes.
Yes, my lord. Because
I will
here,
clarify, I understand it now.
my lord, to avoid that,
No, 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 no.
This
Why should I
practice.
avoid?
he
My
ap-
lord, here, my lord, I have got the
Order.
judgment of the one direct judgment I
For
got.
205, I did not hear so many things.
My-
I will give you opportunity to appear VC
Yes.
and you have to.
at the time of trial, my lord, because on the
Okay,
charge, he
yes.
will not.
At the
That's why.
As and when required.
That, my lord, always open for him.
Physically appear
Yes,
and bail and all, you have to get it.
That, my lord, that is always open to him.
In the
Once-
garb of 205, you can't get indirect bail.
I'm fully with, I agree with you, lord.
Okay, I'll pass.
One thing your lordship may take note, my lord.
Hmm.
He appeared before the special court through lawyer, my lord, on 10/12/2018. Now we are in 23.
No, have I
24
ever-
has come. Till date, only adjournments 205. This is going on, my lord. For
No,
that, the
what-
special court is unable to proceed.
He's not on bail.
He is not on bail. That's why I.
Charge that only.
That's why I was citing a judgment, my lord.
No charge
This
has been
court-
framed yet.
You,
I'll
and
record
you are
that.
not appearing. How
But
charge will
frame sangre kon achi ba?
unless this judgment was passed by this.
What is the stage of trial now?
My lord, he is not appearing. Where is the question of charge could not be framed because these people are not appearing.
I am not the single accused.
This
There are-
judgment, your
my lord,
lordship,
there
kindly
are-
see.
Which paragraph?
Paragraph
see,
7. Your lordship straight take paragraph
Miss
11.
Pal, wait, we will balance it.
Paragraph 11. Yes, my lord.
Balance it. No,
No,
what-
my lord.
paragraph 11.
11, my lord.
Okay. Yes. 11. Yes.
On the other hand, Mr. Gopal Agarwal has relied upon the decision of the apex court in case of so and so and is referred. On the basis of the decision cited above, Mr. Agarwal firstly submits that economic offense or white collar crimes cannot be equated with other cases because of their wide ramifications such cases have on the economic security of the country. He further argues that prisoner has not made out a case for exemption from personal appearance as he is a resident of Bhubaneswar. Here, my lord, he is a resident of Cuttack and can easily be attended the court without adversely affecting his business. By insisting the personal appearance, the learned special court has given the prisoner opportunity to seek bail by offering sureties and executing bonds by subjecting himself to the jurisdiction of a court through a bond to the effect that he shall cooperate with the trial by abiding the conditions imposed by the court. Having heard, then my lords have quoted the Bhaskar Industry judgment. And this judgment, my lord, I have given the Supreme Court.
Bhaskar
Was
Industry, I
challenged
also
before
will
Supreme
rely.
Court also.
I know.
Supreme Court said blanket exemption cannot be granted.
I'm not giving that. I'm not-
That Supreme Court order also I have
what-
given.
That judgment.
When is the PMLA case started? That is annexure P1.
One, my lord, 13/7/2018. And the court, another thing, they said that three cases are registered against me, the schedule offense. When they filed the complaint, 2 cases were already quashed by this honorable court. That has also not been, that is the way they are going on.
My lord,
Out of 3 cases, 2 cases at the time of filing of complaint already quashed by this honorable court.
That third case must be there. This
The
PMLA,
case-
PMLA is related.
Yes,
to
Lord,
that case.
Third case,
a group
just
of-
my friend, just in third case, 15 witnesses have been examined and all them have been hostile. And the only
So
allegation-
therefore, you are waiting till you get acquittal. You will
No,
pull out.
I am not waiting for. I have filed an application. Which is the only allegation against.
I don't think these things are relevant. I'll pass
Yes,
it
yes,
off.
yes, your lordship,
Right.
what your lordship proposed,
When-
I fully agree
Yes,
with your
yes.
lordship.
When the PMLA proceeding started against you?
my lord, PMLA
13,
13,
they filed on 13/7/2018
13/7/2018.
and cognizance was taken on.
Complaint case bracket PMLA number 60 of 2018 has been initiated against the petitioner hearing. How many petitioners?
My lord, 9 petitioners.
All of you are seeking exemption.
No.
One of the petitioner.
Only me, man.
There are there are as many as 9 petitioners.
No, my lord.
Sorry, as many as 9 accused
Nine
arrayed
ac-
in the complaint.
9 accused.
Accused arrayed in the complaint. Accused number, you are
Four.
accused number?
Four, my lord.
Accused number 4 has moved an application under section 205 CRPC seeking exemption from personal appearance.
He appeared, your
Which has
lordship,
been, which
he
has been,
appeared before the special court, my lord, on 10/12/2018.
that those things, by way of impugn order dated 2/3/2023, the application of the petitioner seeking exemption has been turned down by the special court. Special court Bhubaneswar. Special court
Special court Bhubaneswar, at
Special court
Bhubaneswar.
at Bhubaneswar. Learned counsel for the petitioner, Mr. Pal, learned counsel for the petitioner submits that he is not keeping well, and therefore he sought exemption. On the Mr. Agrawal appearing for the enforcement directorate submits that the petitioner had never surrendered to the jurisdiction of the special court and he has been avoiding to appear in the court. On the contrary, he is moving application under 205 so as to avoid to surrender to the court. Full stop. He further submits that he has not even availed bail from
Bond, man. He is not giving bond.
from the jurisdictional court. He has not even furnished
No,
bond
he,
and
he has even not applied for bail.
he has
Where is
not
the
even
question of?
applied. He has not even applied for grant of bail.
205 is allowed, my lord. Bail is not required. Because all I required is to be my appearance.
I know
before the
that
court.
205 is not a permanent, perpetual thing in
Yes,
a trial.
Because 205
It is a
subsection 2.
date specific thing.
My
You
subsection
can't get permanent exemption
No,
at the age of
not at all. Not at all.
If you are bedridden, you can't move and all this.
Yes,
that's
yes, my lord. Subsection 2 says, my lord, the court can anytime ask for personal.
Anytime means day to day you have to move. Not that a permanent,
No,
complete
that is-
permanent.
No, that is, my lord, 317. That is what you lord.
But that every day it has to be examined. In this day, why you can't come?
No, if 205 is allowed.
205 allow means you will not take bail, you will not face trial. This is not
No,
the idea of
not-
205.
My lord, the concept of 205 is that I will appear through lawyer and as and when required by the court, that is the.
Without even taking bail. Not surrendering to the jurisdiction of the court.
What is the concept of I am explaining? My lord, I am explaining, my lord. Concept of bail is to that secure my attendance before the court. Concept of bail is not that when I am appearing so much.
But after taking bail only.
No, not required, my lord.
You will not take bail at all.
I'm giving an example in 138 proceeding, my lord.
Oh, these things.
My lord,
see,
138
these are
cannot be
very-
compared with the offense under PML Act. Suppose a person commits a murder and he will compare
the
138.
the important thing here is you know what is the scope of 205. He also knows, I also know. So this argument makes neither here nor. Everybody knows here.
No,
Why
I only, my lord,
why 205 is meant and how it is used.
My-
Everybody knows, and you know more than anyone else. Being a defense counsel.
what I was suggesting to your lordship that I will appear as required. if
That's why I'm
first
saying
yes,
surrender to the jurisdiction and appear
Yes, yes.
as and when
That may not always open to him.
That's what I'm saying. Grant a bail in the some case. Having heard the parties and perused the record, I am of the opinion that the application under section 205 moved by the petitioner deserves to be allowed, subject to the condition that the petitioner surrenders to the jurisdiction of the trial court, and the trial court may extend the concession of 205 CRPC to the petitioner to appear through VC, and the trial court may insist for physical appearance as and when
Lord,
required.
before my lord, that at that stage of, because at first he should take the bail Because,
That's why surrendered to the jurisdiction of the court, what I was saying.
yes,
I have balanced everything.
That Bhaskar Industries case, Lordship, that also another clause has been added. I am
all,
that he will not
all
also
judgment
dispute his
will not,
identity.
all judgment has
Another
been
clause
taken
has to
note
be
of.
added that he will not also dispute his identity.
Who will not?
The petitioner will not dispute when he is not appearing. He has to give an undertaking that he will not.
That's the reason I say that you have to, these are the situations where you have never gone. Here is a
No,
situation
here-
you have to surrender to the jurisdiction. Thereafter you apply for VC hearing. As and when physical appearance is
Yes,
required,
yes.
he'll call. Simple.
I'm most obliged.
Simple.
Most obliged. Most obliged.
All the things are taken
What
care
my
of.
friend is saying, all judgment, Bhaskar Industries, all has been taken note of. And this order was taken to the Supreme Court. If your lordship looks to the one line of Supreme Court order, I have given that order also along with that, my lord.
Yes.
The blanket exemption as prayed by the petitioner cannot be granted under section 205 of the code.
Opinion of the Lordship also.
However, if for sufficient, so that is the law, my lord, always. He must go
Yes,
take
yes.
the bail,
That
then
has already
always he can apply.
Therefore, I have taken care of.
Man, obliged. Most obliged. Urgent copy.
Only, my lord, your lordship, because there may be confusion, he must surrender and apply for bail.
You read out that portion, last portion. Just see.
Yes.
No, open. The petitioner surrender to the
Because my lord,
subject to the condition that the application should surrender to the jurisdiction of the
my
trial
lord,
court.
because my lords have said.
Once he surrenders, trial court knows
your
what to do.
lordship has said 205 is to be allowed. So this is not the
I
state.
read.
Once, only one line your lordship may add, he must surrender and apply for bail. That's all only.
I'll do that. Don't worry.
Oblige.
I'll balance both.
Oblige.
You get the relief also here.
No, actually, otherwise, my lord, it will be a problem because in.
I know this will be cited unnecessary.
Yes, no, that is
I
the
know.
reason only.
We'll take care of.
Oblige.
Thank you. Please go down. Yes. Which item next?
13 page.
13. 14? Anybody? Just within 2 minutes I'm coming.
Application for extent.
No, where is the interim order?
My lord,
Yes.
3/2/2023, this Honorable Court, after hearing both the side, granted stay on further proceeding and issue notice to the opposite party. I have filed the requisites. The opposite party number 2 has not appeared, but the proceeding is before the trial court is going on, and as per the judgment of Honorable Supreme Court, 6 month time has been lapsed. Therefore, the
Yeah,
last.
why, what is the service position? Alok Ranjan Kara. Have you served?
My lord, I have served.
Well, let us. No, sorry. Garuda Bhag. Just see the record, whether he is served or not. Copy not served too. You have taken stay and you don't take steps, and now you ask for extension. Let's see, check it up. What is the service track position? Just see.
This is your repudiates, your lordship. I have filed for issuance of notice, your lordship.
Dealing as to must have missed. Dealing as to must have missed.
Hey, what is the position? What is the tracking record? Track record. You get it. It's passed over with that. I'll have to see. I want to extend it if you have taken steps to serve. You have taken the stay. Let us see. Understand. Mere filing requisite will not help. Let us see.
Without filing, they will not
That's
give the
right. You
receipt
have
to
done
me, your
it,
lordship.
but let us see. If he's not coming, it's all right. We'll extend it. Why he is not coming? What is the case, by the way?
My lord, case the petitioner number 2 is forester, your lordship, of Bhavani Panna range. During his service, your lordship, he initiated a criminal proceeding against the opposite party number 2 with allegation of illegal transportation of forest produce, your lordship, with his vehicle, your lordship. Thereafter, the opposite party number 2 pray for bail, and thereafter file a 457 petition for release his vehicle, your lordship. The learned magistrate allow his prayer and directed to release the vehicle, your lordship. Against the said order, the present both the petitioners, petitioner 1 is the DFO and petitioner number 2 is the forester, your lordship. They agreed with the order of the learned magistrate and moved to learned sessions judge, your lordship. Sessions judge also confirmed the order of the learned magistrate, your lordship. Against the said, your lordship, they moved to this honorable court by filing writ application, your lordship, that is pending, your lordship. During this time, the opposite party number 2, who is the accused, filed a complaint case against me that we have violated the court orders. And the learned magistrate.
And this matter is arising out of that complaint case. What is stayed? The complaint case is stayed.
Yes, lordship. Complaint case filed by the accused against the forest personals, that case has been stayed, your lordship.
Or extend it. Extend till next day. And track report, by the order dated 3/2/2023, notice to the opposite party number 2 has been issued by the coordinate bench. The learned counsel for the petitioner has filed the requisites
on 8/2/2023.
On 8/2/2023. However, the tracking, neither the AD card nor the tracking report has been placed on record. None appears for opposite party number 2. Let the tracking report and service position on the respondent opposite party number 2 be placed on record. Placed on. We give in the first week of February. First week or second week?
Second
week. Till the next date of hearing, the interim order granted on 3/2/2023 will remain in force.
Urgent copy, your lordship.
Will remain in force. Copy you will get it. Yes.
Item 50.
I may please, your lordships.
Yes.
But here is a small point involved in the case is, but in a DB proceeding, the proceeding has been filed under section 12 of the DB Act, some proceeding was filed. Thereafter, the application for interim maintenance was filed. But the law is well settled in the case of Rajnesh versus Naya. That the date of application of the interim application, the interim award is to be granted. By analyzing many cases of our High Court as well as different High Courts of the throughout the country, as well as the Supreme Court. The Supreme Court at last arrived at the conclusion from the date of filing of the application of interim maintenance award is to be awarded. But here is a case, mirrors. the London Magistrate has granted award, my lords, from the date of filing of, my lords, the
Application.
the 12 application, original petition, my lords, that is application, not on interim application. That is
When the interim application was filed, what is the difference?
my lords, difference is the original petition was filed on 16/11/2015. 12 application.
And,
Then 23 application 18/11/2018, my lords. Sorry, 17/9/2018.
What are you doing
My lords, I
for
am
living?
my lords,
What are you doing for living?
my lords, my lords, I am the husband and working, my lords, but
What working as what?
as a revenue officer, my lords.
Revenue.
My lords.
Your wife is a housewife.
Yes, as a housewife. Now,
Do you have any issue?
no, nothing, no issue.
What is the amount of differential amount?
Differential is many more.
If your prayer is accepted,
My lords.
what will be the difference?
Difference is more, my lords, around 2.5 lakhs.
Your revenue officer. What
My lords, I'm salary.
After all, you are paying it to your wife.
My lords, I have paid. I have.
What is the arrears?
Lords, arrear now it is no more arrear, rather more than
You have already paid.
already more than paid.
You want to recover it.
What?
If you have already paid, no question of recovery.
No, lords, no question of recovery.
She might have already spent the money. Where
Right.
from she'll get?
My lord. My lord.
Why to interfere then?
But my lords, my responsible submission here, let's let the amount be stayed. Because now
You have paid, she has spent it unnecessary. After all, she is your wife.
No, my lords, it is correct. Your citizen hundreds, I'm buying dying before lords. It is
If you
correct.
have not paid, one can
Yes.
understand.
Yes.
Paid it.
So I have already paid, my lords. My lords, my amount as per the my lords order, 4,56,000 is to be paid. But I have already paid. I have the data, my lords. That is 4,66,196. More than that. Still matters. My authority, as per the direction of the court, matters. My authority is deducting salary, matters. So that is also there. That is not. That is per month 33,915. Already.
Monthly, how much you are paying?
Yes, matters. That is monthly.
33.
33,000.
How much you are getting?
I am getting there. I am getting 61,020. 61,000 पाउची 34,000 राउंड होची 33,919 माने 34,000.
You have a paramount.
Yes,
You
no,
have a
no, I
paramount.
don't have paramount. I have not yet entered with that. Nothing is there.
So simply we will issue notice.
No
question.
Stay sir, no
In a maintenance case, what say?
No sir, say date of application था, say date of application.
That you may have, but you have already paid.
Sir, already
There is no question of recovery, you know.
No, I know that.
Then
for that minute, as because I have paid more than that. So I want a stay.
see in these kind of cases, if the stay is granted, why should the court will believe whatever you say is correct?
No.
He may give a different story.
Yes, sir. For that,
So let us issue notice.
notice.
Don't insist for stay. Issue notice to the opposite party number.
May I submit one thing? Since my wife is remaining at Bhubaneswar, I can take a notice by special messenger.
You take
yes,
and I'll put it next week.
Yes, ma'am. I don't have
no stay.
But till then, can I say sir काटी देबे वर्तमान से देखन सर मु देख देई सब डॉक्यूमेंट
काटी देले कोन जो आपण
सर मु अधिक देई सरिनी अधिक देई सरिनी
काकु देलेनी
मु वाइफ देइछि
काकु देइछन
वाइफ देइछि
वाइफ को देइछि
सर किंतु अधिक देई सरिनी ताको जहा कोर्ट
आउ काकु तो देइ नांती ना
ना सर देइ
ठीक हो जा if it is excessive paid final maintenance we will see you adjust it
sir वर्तमान मु जदी फैक्ट को सर आनी बिफोर दिस ऑनल कोर्ट
no don't get it on this
sir.
Next week dasti
हां सर
next week
सर till then sir stay
no question
असुविधा हो सर मु अधिक देइ सरिनी मु डेक को देखो
fundamental is in a maintenance petition don't interfere.
No, my lord.
That to interim maintenance.
No, my lord. What is here is a case, my lord. Date of maintenance, sir. The 15 application for this.
You may be correct since you have paid it. Where is the question of stay?
Sir, I have paid more than that. So if you have, unless and until your lordship protect me, then यही मात्र अपने काट देबे. 9 तारीख तक काट देबे सर. 9 तारीख में काट देबे. सर अधिका मते यही सरिनी.
गोटे मासे तो काटी.
ना पुणी सर 33,000 34,000 देबी सर.
9 तारीख काटी. 9 तारीख काटी है ना.
9 तारीख
8 तारीख रासन तो.
सर मु नोटिस
8 तारीख मु डिसाइड कर.
8 तारीख से सोमवार आछि.
Oh, I'll decide it on that day.
Again, mु notice ta 10
take dasti sir and on 8th see if it doesn't come after service I'll stay. But give an opportunity to her.
Yes.
8th, huh? Dasti requisite to be filed during the course of the day. Dasti notice to be issued to the opposite party number नहीं opposite party one sole responsible ठीक है आपने during course of the day file कर नहीं जानते service कब तो 8:30 decide
ଏବେ sir ଯଦି 2-3 ମାସ ଡିଫରେନ୍ସ ଥାନ୍ତା ମୁଁ କିଛି କହିନଥାନ୍ତି 3 ବର୍ଷ ଡିଫରେନ୍ସ
ଆପଣ 9 ତାରିଖ ନ କହିକି ଆପଣ ଯଦି କହିଥାନ୍ତେ କାଲି କଟିଯିବ ହେଲେ କିଛି ହେଇଥାନ୍ତା ଆପଣ ଗଲତିରେ ନ କହିଦେଲେ
ମିଛ କାହିଁ କହିବେ ସାର୍ ଦେଖନ୍ତୁ ଅଛି ରେକର୍ଡ ଯାହା ରେକର୍ଡ
ହଉ ଠିକ ଅଛି 8 ରେ ଡିସାଇଡ କରିଦବା ସାର୍ ଲାଗି ହଁ
Item 16.
16 na going slow today
one week after matter has
we are going slow today so yes
matter has already settled between the wife and husband, dispute between wife and husband.
Where is wife?
Wife is not come. Keep it next week or 1 week after. She will come and file a petition.
Yes. Next week, give a date. The counsel for the petitioners. This is a dispute arising out of a matrimonial.
Yes.
This is a matrimonial dispute. Matrimonial dispute, and the counsel for the petitioner submits that the parties have settled the dispute out of court. So let the petitioners and opposite party number 2 file a joint affidavit and also present before this court by next date of hearing. Next date of hearing. 12? 13. Saturday, na? Then 16? 16.
Item 17.
Yes.
Last occasion, the lordship directed to take instruction regarding examination of witness. In this case, I have before the petitioner is before the Hon'Ble Court for passing of the criminal proceeding on the ground that the matter has been amicably settled between the parties and the complainant PW1 and the husband PW2 deposed before the court below that they do not want to proceed the case. On this ground, the present petitioner is before your lordship for passing of the criminal proceeding. Last occasion, your lordship directed to take instruction how many witnesses have been examined, except those two, the complainant and her husband. None else has been examined. I claim deposition the minor pays.
The deposition is there. Then we will expedite. Alert.
The last occasion, your lordship.
Expedite. See, I can't scuttle the trial like this. We'll give it 3 months.
One thing I say, minor. Bank of sir. The order passed by this Hon'Ble Court will not be precedent to the other two accused.
Because there are how many accused? 3.
Only in respect of the present petitioner will not be precedent to others. Bank of sir, that is problem.
No, you are appearing for one of the accused.
Only.
You confine your argument to the benefit to which you are getting. It should not be extended to other accused. What is your interest in that?
Your lordship said last occasion, your lordship taken a view.
That goes to show that you have won over this witness.
No.
You might have paid for you, and the other 2 witnesses might not have paid.
My lord, it is clearly legit that he has taken the money from the police that has.
So why are you pleading that? You confine. See, the witnesses have not said anything against you. They say that we don't want to pursue against this. There are 2 other accused persons, and you are asking for quashing. You say it should be quashed, but not against the other people. Other people, they may take advantage, may not take. How does it make difference?
Last occasion, your lordship has taken a view that why I will quash the proceeding. Let the trial be completed.
Yes, 3 months. 3 months. 3 months I'll give. Where is that deposition?
My lord, page 13 and 14.
Yes, right on.
13 is the PW1.
Petitioner has invoked the jurisdiction of this court under section 482 CRPC seeking quashing of the criminal prosecution against him in GR case number 420 of 2021 pending before the court of civil judge junior division Ersama. The the allegation. Where is this? Yeah. The allegation against the petitioner is regarding the offense committed under section 419, 420, 479, and 34 IPC. The petitioner has placed on record the deposition of the PW1 and PW2.
Pardon, my lord.
PW1 and
PW2, my lord. Pardon, my lord.
this is PW1.
My lord. I beg pardon, my lord. Except the IPC of there are 66C and 66D.
And 66C and 66C and 66
D of the IT.
D of the IT Act. And he has placed on record the testimony of PW1, who is the victim oblique informant in the case. The victim very specifically a victim in the paragraph 1 of his deposition is very specifically stated that the dispute has been amicably settled outside the court and he doesn't want to proceed with the case. He has also stated that he has received rupees 3 lakhs from the petitioner.
From the police. That is
He received 3 lakhs from the police, from police, white Jimanama number so and so. It pays 13. Therefore, he doesn't want to proceed with the case. On the strength of the testimony of PW1, the petitioner has filed this present petition.
Also, my lord, PW2.
See, next, the PW2 also deposed before the court in the similar line. Therefore, on the strength of the testimonies of PW1 and 2, the petitioner seeks quashing of the proceeding against him. The Land Council for the state submits that there are other witnesses to be examined in the present case. And he also submits that apart from the present petitioner, there are other two accused persons facing trial. Other 3 accused persons facing trial.
Other 2.
3, just see page
Madam.
3. Other 3 accused persons also facing trial along with the petitioner in the instant case. Next problem. Taking into consideration the facts that have of the case, it would be appropriate that the trial court is directed to expedite the trial. Next part. Accordingly, the petition is partially allowed with a direction to the trial court to conclude the trial as expeditiously as possible, preferably within a period of 3 months from today. Okay, next. Item 18.
Item 18, I may be permitted through VC, my lords. My lords, I may be permitted 10 days time to implead the informant as OP number 2. Because during the pendency of the application, there has been a compromise, mutual compromise between the parties. And the informant wants to appear as OP number 2.
You are for the petitioners?
Yes, my lords. So I may be permitted to implead the informant as OP number 2, my lords. I will file. Yes.
What is the offense?
Offense 307 and other offenses, my lords.
The counsel for the petitioner submits that. What is the stage of trial?
It is as per my instruction. It is investigation is going on, my lords.
Investigation?
Investigation is going on, my lords.
Going on.
Yes.
Investigation is going on. How can we?
He applied for antecedent that has been withdrawn.
Yes, that is different thing.
No, what that is different. You never know in charge sheet what will come out.
Because let them appear a lordship.
And after all, it is 307. You
Yes.
implead them, let us see. The counsel
Yes.
for the petitioner seeks liberty to implead the informant in the FIR laws against him as the opposite party number 2. Liberty is granted. Let the petitioner file amended memo parties and requisites to serve the opposite impleaded party number 2.
My lords, I will file a consolidated cause title, my lords.
Yes, yes, I have said amended memo parties. Okay. Did this February.
So, your lordship directed to file
How much
requisites.
time will you take to conclude the investigation, Mr. Agla?
Hello?
How much time will you take to conclude the investigation?
That will take on the next day.
Second week of February?
Marat.
Second week of February.
So, your lordship directed me to file requisites.
Yes, yes.
Okay.
You have to file the requisites, file amended memo parties.
Yes.
Impleading him.
Only I will take instruction from the
Yes, yes.
Your lordship.
Huh?
Your lordship posted it to
6th February.
my lords.
Item 19.
Mulad, item number 19, I'm on VC, I may be pardoned, Mulad.
Yes.
Mulad, there are two applications on at item number 19, Mulad. I'm appearing in CRLMC 2548 of 23, Mulad.
There are two. 3. Yes. Yes.
Mulad,
You are
in
appearing-
2548 of 23, I am being led by senior counsel Mr. Shauri Mahapatra. Mulad, on behalf of him, I was seeking an accommodation till about next week, Mulad, or any day of that.
Adjourned for 2 weeks.
My lord, my lord, I'm for the informant. It may be adjourned to next week, my lord. My lord, the trial has been intense interim order to stay the trial.
There is an interim order.
My lord, it may be hard.
See, there is an interim order and there is opposition also for adjournment. Where is the interim order? Interim order passed, earlier continue.
My lord, short adjournment the next week. No objection if it is adjourned to next week.
What is this matter?
Well, this
my
is
lord,
a matter.
they have challenged the order of cognizance against the present petitioners.
Offense?
302, my lord.
And it is stayed and next week.
Other two matters, your lordship. Your lordship, there is two other matters, your lordship.
Yes, it's all the 3 matters next week.
Item 20. Item 20.
My lord, one small payment in second sub item. In first sub item, we have filed as memo of citations. That is not in the noting. That may be also.
Oh, next week we'll point out. Yes.
Last time, I guided me to apply this court regarding the maintenance of the petition of quashing in a case under POSCO, madam.
The account that payment has been stopped. Then I requested again. Again, he said, okay, you file on October. Again, I submitted. Again, that one was stopped. 2018, after I filed this NI complaint case under Section 130 NI Act, he filed a criminal case after 6 months against me that my checks have been stolen. And complaint case was filed. Investigation was made.
That is his defense in
Defense,
your,
yes.
in your
To frustrate my case. Now, thereafter, what happened, my lord? After investigation, report came out that is a false case. It was over. Then, my lord, it was there still. Then again, he filed a protest petition. In the protest petition, the guise of protest petition, despite I have got an order from this honorable court, this 138 NI Act of the year 2017 shall be disposed within period of 4 months. That has been now frustrated. For which reason I have come
in the protest petition, cognizance has been taken.
Protest petition notice has been issued, investigation has been carried out.
No, protest petition cognizance taken.
Cognizance taken. No, sorry,
but he has not filed the order of cognizance
and
and
I have
also
no
the
instruction that
initial
because I have
protest.
What is the position in 138?
138, my lord, unable to hear the court is unable to hear the matter. because this protest petition, because if
But
it
it's a
will be
case.
found that tomorrow I have stolen his checks, now obviously this case will be frustrated. My case will be frustrated. But I kindly appreciate my lord.
But both the prosecutions are independent. It's not contingent upon each other.
Yes, my lord, that both.
And the 138 case is prior in time.
Yes.
138 case is prior in time.
Yes, ma'am.
And his complaint case is subsequent there. So 138 should proceed.
Exactly, my lord. But the court is not proceeding, my lord. Now, one more thing, my lord, kindly appreciate.
Then what do you want now?
My lord, I have come up here, my lord. If the notice will go to other side, he can appeal with your lordship. The thing which has already been clear, the checks were.
What is the check amount?
3 lakhs rupees only, my lord. And there is a poor petition of my 3 lakhs rupees. He is running below to post since last 6 years.
He is willing to pay a little bit less or a little bit more.
If he can agree, my lord, I have no objection. If he will come here and
okay, issue notice.
My lord. But I cannot preferably stay because
you are aggrieved because of it is stalled. Again,
Yes.
you want to solve yourself by
Exactly.
application order.
Well, because I have my one more thing, my lord. I have come up against his case. The protest petition which was accepted by the landed court below. Once completed.
Even if that is stayed also, it will hurt you.
Exactly. So that is why I am not paying any stay, man.
Simple notice will come.
May short date may kindly be.
You
4 weeks time maybe, my lord.
You serve if you can.
Well, notice will be served when I have to send. So take notice, man. File the report.
He is from Mayurbhanj. Will you take Dasti?
Dasti costly you बिचारे दे परिवर्तन 3 times multiply करिया पड़े यथी जीवा से 2 and 4 था 3 times special message will sufficient sufficient
issue notice.
One noting is there, my lord. Earlier 2 CLMC applications are there, my lord. Not back 1 and 2.
One I had filed for targeting my case 138 NI case.
What happened?
It has been disposed of within 4 months. It has to be disposed in the month of June. But that copy is with me.
Yes, next.
And next other one was filed with other side, which was withdrawn on 20th March 2023.
Withdraw. They
And
filed for what?
Well, I don't know what to do, but it was filed and I obtained the copy from both sides. That is their petition that has been withdrawn. And this is my petition. That is an order.
What is this petition, by the way? What?
But that is their petition. I think both the Supreme Court.
He might have filed
Yes,
quashing up 138
Yes,
case,
ma'am,
saying that it was stolen. I know.
Yes, ma'am.
I understood it.
Yes, ma'am, that is.
Both the cases tax. Obviously, he will file it. Court might not have agreed.
Yes,
Withdrawn. Okay.
Yes,
Notice.
ma'am. My lord, you'll also be retained into judgment fixed.
You tell me when.
My lord, any 3 weeks up to within 3 weeks.
3 weeks.
Any date maybe. Oblige, my lord. Requisites file, my lord, within 3 weeks, 3 days.
Yes. During the course of day, you file. Tomorrow.
File kind of.
Tomorrow.
Day after tomorrow.
Day after tomorrow.
Oblige. Oh, Saturday. Tomorrow Monday, by Monday. Tomorrow is Saturday and
okay.
Monday. Oblige,
by Monday. Requisite to file by Monday. Yes.
I may
Next.
pardon, ma'am. Item number 20, instead of 16, let it be on 18, madam.
18.
18.
18. Instead of proceeding देखी देवे ये लिखी नहीं था ना proceeding गलत नहीं अपन लिख
Item 20.
चार लोग
Item 20.
yes
Item 22.
Please, Your Lordship.
Yes.
Your Lordship, the petitioner prefer 482 bail application for default bail, my lord, in the absence of C report, Your Lordship. Your Lordship may kindly peruse the synopsis list of dates, Your Lordship.
Yes.
The FIR registered on 26th August 2022. And on the very same day, the petitioner arrested by the IO. And on 27th August, he forwarded to the court below, Your Lordship.
Yes.
Thereafter, my lord, on 17th November 2022, after 83 days,
right,
the IO submitted charge sheet without having C report, Your Lordship.
What happened to that Supreme Court?
The bench matters is pending, my lord. Arbaz Khan.
Arbaz Khan.
Muhammad Arbaz and others, the bench matter is pending.
You go to trial court, raise this.
Your Lordship, the petitioner already raised the points before the learned court below. That is the annexer, my lord. Three series, Your Lordship. Page starts from page number 37 to 48.
Yes.
My lord, page number 45 may kindly.
You have impugned this order.
Yes, my lord. He already preferred the petition under 167 subsection 2, saying all these things. And also relying the Muhammad Arbaz, the pending bench matters order.
what is the, what are the facts?
The fact is, my lord, starts from page number 617, your lordship. The
17.
present petitioner transporting ganja weighing about 48 kg 900 gram.
Okay.
My lord. In the conscious position, this is the.
What is the story? You were doing where? Where from where?
My lord.
We chased the immediate person. Spot. We found the
Is it? We found 6 number of airbag from him, which smell ganja was coming out. After that, my lord, seeing the police party, they started running from the spot by leaving their bags.
Okay.
When the patrolling party patrol at that place, they found the present petitioner and others transporting ganja. But in this case, the present petitioner is arrested.
They were going in a train.
Train, man. And that contraband seized from the seat below the seat.
I faintly remember. I think I have appeared for one of the accused in this.
No, that is another material. This is another
case. The story appears to be matching.
Because the Titlagarh GRPS conducting those cases investigation like this type. More than 20 cases are there.
Story appears to be very familiar
like
to
this,
me.
my lord.
I have appeared for one of the cases at one point in time.
In 20 number of cases, the story is same, my lord.
Oh, they might have kept copy paste and changed the name.
My lord.
One thing, my lord.
What is the Sessions Court says?
One thing, my lord, I want some time, my lord, to obtain the case diary. As because, my lord, the page number 47, in the paragraph, third paragraph, my lord, first last 2 lines. Moreover, chemical examination report has already been received and the same is available in the record.
47.
My lord, 47. 47. Input order, my lord. Internal page 11, running page 47.
No, what happens? I tell you.
My lord, I said that on the particular date, when the charge sheet on that date, it is not available.
I'll tell you, there is another problem here. The police generally file charge sheet because there is a limited time. They file the charge sheet without chemical report. What happens is, they send for chemical analysis report, it doesn't come in time. So they file it because if they don't file 167, benefit will take and go. So they file it. When they get the chemical analysis report, they simply go and put it there in the court. It is not permissible.
For that reason, my lord, I want some time.
It is not at all permissible. How, in what way you can introduce a document?
He must have mentioned the charge sheet that such and such, while sending the charge sheet to the court, my lord.
What they do is, in a memo, they go and put it in the court.
My lord.
But there is no provision.
There is no provision on CRPC that you can introduce any document at any point in time. So therefore, your charge sheet itself is incomplete. He is entitled to 167 to benefit.
That is some decision.
How you get the case diary? Let us see how he has introduced this.
My lord. That is, I will ask also IO.
Issue notice. Let the opposite party number 1 produce case diary to ascertain as to whether the chemical analysis report, which was not filed at the time of along with the charge sheet, has been placed on record or not. Date, hold on.
May I pray one thing, Your Lordship? Your Lordship may kindly call for the LCR also from the learned court below, Your Lordship, because the LCR have the all order sheet. If they receive,
it required LCR. LCR, once the LCR we call, then it is tantamounting to staying of the trial.
Grateful.
We'll see. Let the CD come. Because from the CD you can find when he got it. Okay. 13th. Huh? 30th. 30.
Grateful, Your Lordship.
Item 23.
Made fully close. Lordship, without going to the merit of the case, Lordships. In fact, it is a 3-level petition that has been rejected. In fact, the petition itself has not been mentioned the questions to be put to the witnesses, Lordships. So I permitted to withdraw to file a better petition.
1 minute. What is your what you call, who is this witness?
Witness,
Who is this witness? Why do you want? Whether opportunity was given or given to you? It is a vigilance case. Is it a vigilance?
Yes, sir.
So the vigilance people, pass it over. It may not be required. See, if at all I have to allow, I will allow, and the questionnaires will be examined by the trial court. Why to waste? We will withdraw again your file. Not necessary. Let us see. If you deserve merit, then we will allow it.
I have not served the copy to the vigilance also. Let it be next week.
Okay, you serve the copy.
Yes, sir.
And meanwhile, if you have a questionnaires, come with the questionnaires. Place the questionnaires also.
Yes,
We will decide why to withdraw and again file it. Burdening yourself. Okay. 11. Any date? 11. 11. Yeah. Okay. Next, how many matters are there?
24 we have covered. 24 up to
44.
24 we have covered.
40 matters. Huh?
16.
Any mentioning for adjournment? For adjournment, any mentioning?
Item 28 one.
20?
28.
Adjourn.
Praying for adjournment one.
Adjournment. 2 weeks thereafter. 2 weeks. 2 weeks.
29.
Any
Item 28 is a connected matter. There's two CRLMCs. Let the second CRLMC be taken up today at least. The first, he's appearing for the first CRLMC.
You don't want adjournment.
No, mine matter is
There are two
different from
matters
this.
actually.
My prayer is different. We are against separate.
How it is got tagged?
It's probably happened in the registry. This has never, both the matter has come up for the first time. But
Different
because
matter.
it's the same person, the petitioner is same, probably they have tagged it in the registry because it has never been ordered by this court.
Don't adjourn.
No,
Let us see.
Why it has been tagged? Because the names you also may kindly see.
The
Same
petitioner is same.
Same petition.
Maybe something to do with.
Same petition.
Don't adjourn. Let us see there. Okay. Any more? Okay.
Take out.
Nothing.
Private person Keshav Gowda,
Kesav Gowda.
Keshav Gowda and Jagdish Patnaik, Amyo Kumar Mishra, and
Just see which is the accused number, Amyo Kumar Mishra. Number?
Amyo Kumar Mishra.
What is the particulars of Amyo Kumar Mishra? Turn up and all. Where is that?
Out of this, my lord, 10 persons, forest ranger, Mr. Vishnu.
I'm asking something else. I'm asking something else. Amyo Kumar Mishra particular. Because this name sounds similar to whom I know. Therefore, I may not hear this fact. That is the reason I'm asking. Let's see. Huh? Verify. He is from Jaipur. What I understood. From here I read it.
Amyo Mishra name is not there in the FIR menu. Because Jagannath Sahu, Sushil Kumar Naik,
No,
Vishnu
he
Kumar
read
Naik.
out somewhere.
Charge to the accused Rajesh.
Just see page 15. Just see page 15, para 3. Read it. Got it?
Yes,
ma'am.
Just read.
Amyo Kumar Mishra of Jaipur.
Of Jaipur has the conspiracy with the officer of the forest department, revenue department, of the timber from the government land as well as the private land. Who is this Amyo Kumar Mishra of Jaipur? Because somehow I sounds familiar, this name. Verify and tell. Otherwise, I will not hear this matter. If I am thinking the same pattern.
Yes, taken up 2 weeks after Milo.
Because I'll tell, there is nothing to hide. I tell you, he is supposed to be the elder brother of my class fellow. If I am not mistaken.
Hon'Ble, I will verify also.
So therefore, I may not hear this. Just check it up and tell me.
2 weeks after taken.
2 weeks.
I may kindly be heard, my lord.
Next.
I may kindly be heard, my lord. Just
address. That is address hochi Madara Street, Jaipur, PS Jaipur, District Koraput. At present, Devi Kathogola, plot number 1495, Noyapalli, Bhubaneswar. Now he is residing at Bhubaneswar.
Father's name?
Father's name, Vrindavan Mishra.
I'll also verify whether it's the same guy or not.
He may not be connected to the case.
I don't know. I'll just verify why it stood out. Next.
my lord, I may kindly be heard in the matter. Just last, my lord.
Your lordship adjourn it to
Your lordship.
18th. Can it be 17th? 17th.
Your lordship may kindly hear me.
My lord, I'm sorry to.
Am I audible, my lord?
Due to non-contact of the accused petitioner with the informant, my lord. Because they are
You only took the time today.
No, I pray for.
Both party directed to appear through the IO. I contacted the IO. IO told me that they will never come to the PS. As because there are other cases against them.
Doubtful case. It is a doubtful case. If you have settled the dispute, you should have gone.
I pray for my lord 17, my lord. Paper 17.
17.
Further go to the IO.
My lord.
That may be, my lord.
Can I modify this order?
No, I will not modify. You have created doubt now.
No, my lord.
Nobody, you do it, otherwise I will dismiss in that way. If you say that it has been settled, then you should be
already settled.
Then what is the problem? I am not asking you to appear in this court. At least go to the IO. IO will identify at least.
A file done appeared before the IO. IO will send.
That is the
that is the order, my lord.
17, my lord.
17. Yes.
Item 6.
In item 6, lordship, I am praying for an adjournment, lordship.
Adjourn. 3 weeks. Yes. Next.
25.
Yeah.
My pleasure, lordship.
Yes.
Challenges the legal proceeding initiated in GR case number 301 of 2014 law, pending in the court of law and JMFC people in law. The petitioner is the son and the petition number 2 is the mother. But the marriage was solemnized in the year 2011. 2011 between the petition number 1 and the victim. That there was a love marriage. And since there was no issue, in spite of several check-up before the medical authority. In 2014, and that apart also, the husband of the victim, means the petition number 1, was unemployed, for which the father of the present petition number 1 purchased one auto rickshaw on loan. And the installment amount was also not paid by the petition number 1. And once of time, the father of the petition number 1 gave rupees the installment amount to deposit in the bank. That was also not deposited, and that was disturbance in the family. And taking the same miller, since the husband of the victim was unemployed and that there was no issue, and she committed suicide in the year 2014. However, affair was lodged under section 302, 304B by 34 IPC and under 4 DPI. But charge sheet was filed only under section 304B, 498A by deleting the offence 302. The lordships may kindly see the present petition number 1 was also, petition number 2 was also granted anticipatory bail by this honorable court, wherein it has been observed the details fact of the case. May I go to the lordships, kindly see Annexure 5, page 26. The order of this honorable court in BLA bill number 822, 7 of 2004.
Yes.
in the case registered for alleged commission of offence under section 498A, 304B, 302, 201 by 34 IPC, read with section 4 of GP Act.
Petitioners are in-laws.
Yes, in-laws, father-in-law, mother-in-law, they moved with her. Husband, by that time, the petitioner was in custody. The fact has been narrated what I have submitted before your lordship. That is the.
That's right, they may be fact.
Yes.
It is subject to trial.
But your lordship say kindly for a moment. In fact, there is no demand of dowry, no torture, nothing. The
All
independent
these things
witness.
has to be adduced on evidence.
My lord, the independent witnesses, what I have annexed the document, the 161 statement of the immediate neighbor, who are the independent witnesses, have categorically stated. I am placing the relevant.
The 161 statement is also be subjected to test under the trial.
Yes, that's true. But if
161 statements are not the
accepting the
evidence.
entire materials available on record, if there is no prima facie, there is no material against the petitioner, unnecessarily they will face the trial. That is the their witnesses independent also categorically stated.
What about the informant?
Informant, my lord, the father of the deceased.
What is his statement?
His statement is that the omnibus allegation all are demanding dowry and they have
That has to be tested. That is why the trial is.
That I don't dispute that. But
Unfortunately, that is the law. We can't analyze the 161 statement of one witness qua the 161 statement of other witnesses to doubt the first
But
one.
why I am saying so?
See,
Vilas?
all the 161 statement has to be tested in the trial.
Yes.
Okay.
That's true. That's
so. There may be few witnesses might have spoken in your favor. Few of them might have.
No,
spoken
why I am
against.
stating so? Because they are the immediate labor. They are a different village.
Maybe.
The informant and other witnesses, the mother and others, they are two different villages. They do not know what happened in the relevant
All
night.
these things are fantastic for the purpose of arguing at the final stage.
May I pray one thing, Lord? Your lordship may kindly observe. I will raise all the points before framing at the time of framing of charge. Your lordship, on that observation, lordship may kindly.
That is always there, but I don't think. See, but don't delay it further. It is not to your.
Your lordship, with that observation, kindly dispose of.
You have moved application under 227. What?
No.
Discharge application.
Hello?
You have moved an application for discharge.
No.
Cognizance.
Cognizance order.
Cognizance order.
Yes.
The petitioner has assailed the order dated 3/2/2018 passed by JMFC Pipili in GR case number 201 of 2014, whereby the learned court below have taken cognizance of the offence under section. Where is the cognizance order?
Next page, page 17, 17.
Cognizance of the offence under section so and so.
498A, 304B.
That is that you will take it from 60, page 60. Also, the petitioner raised various points to persuade this court that no prima facie case is made out against them and seeks indulgence of this court at this stage. I am of the considered view that this is not the appropriate stage to enter into the merits of the case and examine the veracity of statements made by various witnesses under 161 CRPC. Therefore, no interference of this court at this stage is called for. Having said that, it is open for the petitioner to raise all his contention at the time of argument on
Time of
charge,
framing of charge.
argument and charge, argument of framing on charge. But the petition is disposed of accordingly. Next. Yes.
26. My pleasure, Lords. In this case, my lord, the petitioner have challenged the order of cognizance dated 2/8/2021, my lord.
What is the offence?
My lord, 498 294, 323, 506, 354,
Who are you?
Lord, I am the husband and in-laws, my lord. The matter is been amicably settled, my lord.
Settled.
Both are living together and
Raj Lakshmi Das
yes,
is the
he's-
informant, is
yes,
the wife.
she's present also.
And Surendra Kumar Das is the
Husband, my lord.
husband.
Both husband and wife.
Anand Kumar, Anand Kumar Das.
My Anand Kumar Das is the brother-in-law, elder brother-in-law.
And Kavita Das.
He is the sister-in-law, bhai bhaujo.
Achha. Mother-in-law, father-in-law are not existing. Where are the petitioners? Come. What is your name? Konna koda?
Surendra Kumar Das.
Surendra Kumar Das. Apanagara? Rajalakshmi. You are.
I'm for the informant.
You are for Rajalakshmi. Have you filed the Wakalatnama?
My lord, I
You,
filed.
you will identify?
My lord.
You can also identify. You have filed a Wakalatnama. What is the offense?
490, 290.
What is the stage of trial?
Cognizance taken. Trial not common.
The petitioner or the husband, brother-in-law and sister-in-law of opposite party number 2. At the instance of opposite party number 2, the FIR number so-and-so under section so-and-so, PS so-and-so has been registered. After investigation, charge sheet has been laid down by the investigating agency. The Learned Court of JMFC Dhamnagar has already taken cognizance of the offences. Against the said order of cognizance dated 2/8/2021, the petitioners have invoked the jurisdiction of this court under 482 CRPC. Also, at this stage, the petitioners and the opposite party number 2 have entered into amicable settlement. Also, the parties to this petition are appearing through their counsel. The parties of the petitioner number 1 and opposite party number 2 have also appeared before this court in person. And the fact that the parties have settled their dispute out of court, and now the opposite party number 2 has been staying with the petitioner number 1 is not disputed at the bar. Having said that, disputed at the bar. Therefore, this is the fit case where the jurisdiction of 482 CRPC could be exercised to meet the ends of justice. Hence, the FIR and FIR number so-and-so, PS so-and-so, and the consequential proceeding thereof, arising thereof, stands quashed. Petition allowed. Yes.
27.
And both of them, and the good like the Mr. So-and-so appearing for the petitioners, and Mr. So-and-so appearing for the opposite party number 2 have have already filed Wakalatnama on behalf of their clients, and have identified their clients in the court. Those who have appeared in person, appeared in person.
7. May I please, yours? But here this petitioner filed this challenging the order dated 5/10/2023. Asked very article and the fact is that
What is this order is about?
Because order we have filed a petition that is at for discharge of section 307 annex 3 page 20. But 307 is not met out, and the ingredients of 307 is also not there. And it's a injury is simple, my lords. If there is a civil dispute and FIR on the same day, half an hour difference, same day FIR presented both, my lords. One is annexure 1, the FIR against me. And where there is crystal clear that allegation is that I, along with my parents, we attacked with stone, my lords. But and there is a simple inside wound. And further allegation is that my wife with a cutlery attack. But the fact remains that 307 has been charge sheeted and cognizance taken. Everything I have also that injury report.
What have you used as a weapon of offense?
Well, with page 10, page 12 is the relevant. This is similar that stone. It's a
12, huh?
Yes.
Page
That
12.
page 12,
1 minute, FIR.
Yes, sir.
What is seized from the spot?
Severe impact is not with me, but I have not.
By means of wooden sticks,
Yes.
bricks, and sharp iron katuri.
Cutlery that has been used by my wife. That page 12 it is clear, and also the eyewitness I will place me. Page 12 or something kindly say I may.
Show me the injury report.
Yes, sir. Yes, sir. And my learned friend Michael, please. Thanks for the copy. I have a copy.
Show me the injury report
Yes,
and
yes, sir. Injury is Lord the Simantu Sahu. And the injury is Lord last page. That is simple one laceration, Lord. And
where is that?
last page, Lord. The flag.
This one here.
Yes.
Kindly provide the. Where is that? Lacerated.
Yes.
Simple.
And same day, Lord, same time, 2 FIRs, one against me, one by my wife. That is annexure 1 is against me, and annexure 2, my lords, same day FIR entry. That is page 15, annexure, lords. Annexure 2, page 15. And offense against me, my lords, sections are 341, 294, 320.
No, this annexure 1 is against you.
Yes, lords.
How many accused here?
Lords, 4 lords, my
Including your wife.
Wife, parents.
Who has used katuri?
Wife has used cutter.
That is the first FIR.
Yes.
What is the second FIR?
Second FIR, lords, this next one is page 15, lords, relevant page is.
No, it's I who has lodged this FIR against
My wife, lords, that is.
your wife has lodged against them.
Yes. One is 352 FIR against me, dated 12/7/2021. That is at page 10. And the FIR given by my wife is 353, dated 12/7/2021. One is reported at 10 PM against me, and my FIR.
Pertaining to the same incident.
Yes. And no, that is another incident. Mine is FIR against me is at 10 o'clock, and my wife gave another FIR at 10:30. That was registered 10:30.
Two different incidents. Not arising out of the same incident.
No.
You can't say that is a cross FIR.
Yes.
It is not a cross FIR.
Yes.
It's a cross affair.
Is it a cross FIR or arising out of the same incident, 2 FIR, or different 2 incident, 2 FIR?
No, it's a
Same incident, 2 affair.
Cross FIR then.
Yes.
That's what I'm asking, cross FIR.
Absolutely.
What is the FIR which is lodged by your wife?
That is at page 15, let's.
That is annexure 2.
Yes, page 15.
There the offences are 354A,
Yes.
506 and all.
Yes.
This is later on time.
That is
Half an hour later.
Yes.
Half an hour later.
10:30 PM against by my wife, 10 o'clock against me, 12/7. And so far as injuries, so far eyewitness not informant is the father is not the eyewitness. So far eyewitness are concerned, I have flagged copies not. They say lot. So far my role is concerned, I have come along with my parents that wooden plank and this brick. So far my wife's role is concerned, there is a assault allegation of assault by cutter. But the 307 has been charge sheeted under 307, even the cognizance was taken.
If there are 3 accused,
Yes.
2 accused use wooden.
3 accused.
3 accused.
Yes.
2 of them used wooden plank and stone and all.
Yes.
And one of them has used a sharp cutting weapon like koturi.
Yes.
and 307 is involved, then can you come to the court saying that I was only holding a stone, so therefore you let me out? It is 34 again. Along with 307, 34 also. Then?
But this annexure 3, there is clear abandonment plots. So far, discharging this 307, annexure 3, page 20.
When is this FIR?
12/7/2021. Both affairs on 12/7/2021.
What is the stage of trial? Stage of investigation? Now it is, yes.
Minor.
Investigation.
Investigation already completed, charge sheet filed,
Both
charge
the
has.
case.
Charge,
As a cognizance is been
yes,
taken.
cognizance taken.
Against
On the-
cognizance.
At the time of framing of charge, a
Hmm.
discharge petition has been filed by the accused persons.
Yet to
Charge is framed.
No,
Charge-
charge is that is fixed to 8th January 2024. My instruction will be verified.
Your discharge application is rejected.
Yeah, that is
Discharge
annexure
application is
3,
rejected.
Annexure 3, page 20.
And the case was posted to.
For charge, have you argued or you are going to argue?
Yes, that page 20, that petition is there, that has been rejected by the annexure 4. That is under a challenge for the lawsuit. Annexure 3, page 20, lawsuit kindly.
No, for framing of charge now,
Yes, yes.
formal
My
framing of
reject-
charge.
Rejecting my application for
The
discharge.
formal framing of charge.
Yes.
Charge
307.
Witnesses in both the cases, common witnesses must be.
From their family, witnesses are there.
Family
From
family
other side family,
Neighbors.
witnesses are there.
Is there any chance of settlement?
Yes, I have to take instruction because
But they have to be agreeing, na? You, what instruction?
because both are neighbors, it's all and the
You have now, come for quashing, thereafter your wife will come. Co-accused case is now quashed, so quash my case also.
so far as
You have not implemented informant also, 307. Let us see if we can think of settlement because cross FIRs are there. Let the petitioner implead the informant of the case as a co-respondent in this petition. The amended memo parties may be filed. Issue notice to the impleaded opposite party number 2. Let the state seek instruction as to the stage of the trial.
Yes, the date has been fixed to, order is there.
And number of witnesses and all. Stage of
Yes,
the
yes,
trial.
yes.
And stage of the trial. Returnable within a week. Let the matter be listed on 19th. And meanwhile, you seek adjournment 19th.
so far IA is concerned, that is
Issue notice on the IA as well. IA as well. IA number 3423 of 2023 as well. Sir, implead.
I will implement not.
Implead file memo of amended memo of parties, and then we'll see. If they'll come, then we'll persuade them to settle and so that it cases are over.
So last is kind involvement, can I implement in court or in the registry? I will implement. So far,
Type copy, you give one type copy.
along with the consolidated copy.
That is amended memo of parties.
Yes.
Consolidated
Yes.
amended memo of
Amended
parties.
memo.
That's what I've said.
So far,
First page you have to give
Yes,
one
yes,
first
I
page.
will file. It's not file an adjournment petition there. Sir.
You do it. We should notice on the
Grateful.
90.
Item 28.
In item of 28, my lord, for first item, my lord, I prefer in the two item, my lord.
No, yeah, somebody mentioned.
Yes.
Yes.
First item, I prefer in short adjournment. Next week, my lord, any date.
But what is the same person?
The same
Mustaq
person,
Alam?
But the, yes. But
How is a very different order? Mine was for transfer of my jail where I am currently and where I am currently facing trial. I filed a petition, that petition was rejected. I have come up against it.
Like here is, my lord, I am challenging the discharge petition.
Huh?
Discharge petition. My discharge petition has been rejected by the current trial.
But same accused.
Same accused.
It can be analogously heard.
But the first application which has been filed 5069 of 2023, no certificate has been given, even though this has been disposed of earlier. On the same ground, it was filed and withdrawn. And CRLMC number 4206 of 2022 and CRLMC 3206 of 2022.
You have not said anything in that.
My lord, I will
No
file the
certificate has been given.
Huh?
I will file the certificate, my lord. That is my.
Hey, why have you not given? Your client should have. Has he told you that you have not given, or he has not told you?
He has not told you. That is my mistake, my lord. Actually, I have to cross check the.
If this will be accepted, then the second case, he is praying for transfer from one jail to another jail.
That is administrative issue. What is the ground of transfer?
Chip, that was vis-a-vis the model year. We had earlier approached this honorable court praying for that. Honorable court directed us to withdraw it, go back and file a petition before the court. That is not ministerial anywhere. I have got the judgment of the Honorable Supreme Court. That is purely judicial decision now. The transfer year has to be considered as judicial decision, cannot be considered as a ministerial year anymore. So, which is why we filed a petition. That petition has been rejected. Against that, we have come up before your lordship. We are saying that since I have been located at a place which is 200 kilometers away from where I am facing trial, it's in a separate district. This trial is going on before.
Well, your conduct has to be seen also.
Region is there, my lord.
Your conduct has to be seen. If your conduct is so,
reason
you will be transferred.
Only bare perusal of the order itself would show that no reasoning whatsoever, no justifiable reasoning has been given. I was supposed the closest jail where
you will not choose the jail.
No, Lordship, I won't. I will not choose the jail. But now this is affecting my criminal defense, your Lordship. I am not choosing the jail where I was supposed to be based on my residence and where the trial is going on.
Petition, have you said that you transfer me to this jail or that jail?
This special jail, Rahul Killa, therein he has given a reason why I should not be transferred there. As per the proper procedure, I should have been there. I agree to that, your Lordship. Yes. But there is another jail which is 60 to 70 kilometers away from my residence and the place of trial. That is sub-jail Pune.
You simply tell me what prejudice has caused to you.
Lordship, 200 kilometers away in a separate district, I am now currently located. I don't have access to my council, cannot have regular access to my council because it's a 400 kilometer round trip. My parents and all, both of them are ailing citizens, senior citizens. I have no contact with them. And this is what Supreme Court says is violative of 21. Under trial prisoners, you cannot cut them off from the society and you cannot cut them off of their regular access to counsel. Because now it has come up to the hearing stage, Lordship. Evidence has commenced, already commenced. Of prosecution witnesses, 3 evidence have witnessed. If I don't have access to my counsel, Lordship.
What is the stage of the trial? The same case where he is seeking indulgence.
Yes, prosecution witnesses have been examined.
At this stage, he is seeking quashing of what? Cognizance order? Discharge petition. Evidence is already recorded.
That is the verse.
Your discharge petition has no.
Yes, my lord.
You withdraw this petition and write down first petition. Write down. The Learned Counsel for the state at the outset submitted that the petitioner has not given appropriate certificate required under the procedure regarding his earlier petition filed for the same cause. Same cause. How many petitions were dismissed?
Mustaq jota file korche present accused is CRLMC 4206 of 2022.
And
the another accused file Aman CRLMC 3206.
There are as many as 482 petitions, 482 CRPTC petitions filed by the petitioner and the co-accused person, which has been withdrawn since they couldn't find favor from the court. The matter was partly argued. At this stage, the Learned Counsel for the petitioner seeks to withdraw the petition. The petition stands petition is dismissed as withdrawn. In so far as next This is 5069.
4743.
4743.
4743. Why there are two petitions?
The 4743, they have prayed for transportation from one jail to another jail.
And 5099. So there are two petitions.
Yes.
Okay. Now let us see this.
Lordship.
Here. Which
Lordship, kindly come to running page 70.
What is the offense against you?
Offenses are 147, 148, 341, 323, 326, 307, 506, 302 is the major offense.
What are the incident?
Read with Arms Act.
Antecedents.
You'll also make a turn to page 74, third para. Very important. The learned additional PP, may I read, Lord?
74.
Yes. Third para. It starts from the word, the learned
Yes,
additional PP.
Vehemently objected.
My Lord, we object the submission of a defense, learned defense counsel on the ground that, as per report of the IO, as well as order passed by the learned SDGM Panpos, Raulkela, on 20/10/2021 and on 26/10/2021, if the present accused petitioner will remand to the special jail, Raulkela, there is every chance of tussles, bloodsheds, loss of human life and writing. That is why this was objected. And the conduct of the
petition. I do not pray to be transferred to special jail Raulkela, which is why this order, this impugned order, is nothing but a copy paste of the order passed by the SDGMI remand order under Annexure 3. That is what my prayer is, Lord. He hasn't even considered what my prayer was. I agree. If my rival, there are two rival gangs, Lord, may call it, rival groups, Lord, may call it. One of them is lodged at special jail Raulkela. Yes, for a moment, let me admit that special jail Raulkela, being the closest to the place where I am facing trial and being the closest to my residence, I should have been lodged there. But since a rival gang is there, rival group is there, there might be a chance of tussle. My petition, Lordship, under Annexure 4 is to transfer me to sub-jail Bonai, which would still be difficult given the fact that it is 70 kilometers away from the place of trial. But at least my lawyers, my parents, my family can access me there. 200 kilometers away, 400 kilometers round trip. I am facing trial in Raulkela. I am being lodged in a separate district in Sambalpur.
Your right is important or your life is important?
That is why Lordship come to the finding.
You are arguing regarding your rights.
Lordship.
They are trying to protect your life.
My life would be threatened in special jail.
Either they are trying to protect your life or they are trying to protect the life of other inmates.
Yes. At special judge Raulkela, that might be an issue. Lordship, I am praying to be transferred.
This is the conduct. You have no right to choose where you will be.
Lordship, kindly see the very next paragraph that my learned senior was placing, the very next paragraph.
Yes.
Heard from both sides, peruse the case record. On perusal of the case record, it is found that the present accused petitioner named Mustaq and Ye were committing murder and are resident of Raulkela town. Further, it is revealed that the brother of deceased, namely Suraj Kumar Shah, and his associates are detained in special jail Raulkela. Lordship, it was never my prayer. Please transfer me to special jail Raulkela. I do not wish to go to special jail.
There is the order.
Lordship, there is the order dated such and such of the learned SDGM Panpos. It clearly reveals that IO has made a prayer to shift the accused from special jail Raulkela to circle jail Sambalpur, as the present accused and his associates are local residents of Raulkela town, and the brother of the deceased and his associates, who are also resident of Raulkela town, are detained in special jail Raulkela. The IO has made a prayer to shift the to circle jail to avoid possibility of bloodshed, loss of human life, rioting, etc. Basing upon the prayer, the learned SDGM Panpos Raulkela allowed the prayer and directed the superintendent of jail Sambalpur to keep the accused petitioner in circle jail Sambalpur. On perusal of the case record, it is revealed that there are two rival groups: accused petitioner and his associates, who are one group, and the brother of the deceased and his associates, who are another group. The learned SDGM Panpos has opined that if both the rival groups were kept in the same jail, there is possibility of bloodshed, loss of human lives, tussle, causing risk to life of the prisoner and jail staff. After considering the above materials on record, learned SDGM Panpos Raulkela has rightly allowed the prayer of the IO to shift the accused person to such and such. The next paragraph. After considering the submission of the learned counsel for the petitioner and the facts and circumstances, this court is of the opinion that the learned SDGM Panpos has rightly passed the order to shift the present accused from special jail Raulkela to circle jail Sambalpur, and some other accused persons are kept in sub jail Bonai, and there is no illegality in the order passed by the SDGM Panpos Raulkela. In the present facts and circumstances of the case, this court is of the considered view that the present accused petitioner shall not be transferred from Circle Jail Sambalpur to Sub Jail Bonai. Till now, he has discussed why I cannot be sent to Circle Jail Raurkela
Don't
because
go
my
into-
rival group is
Don't
there.
go into all these nitty-gritties. See, this is the purely they have to see, because looking into your background,
Yes.
the administration has to apply their mind.
Yes,
These are the courts can't in the ground reality what is happening, how the court will
But
assess.
Lordship, there is no issue.
Your background is very tough background.
Lordship, with this tussle may only happen if
Where
I
is your
am sent to
application?
Raurkela.
Where is your application? Just where is your application which was rejected?
Lordship, may
Show me
come
the
to
plan.
annexure 4. That
Show me the
is running page number 70, Your Lordship.
And you have asked from Sambalpur to Bonai, and the trial court has rightly given the reason. That's all.
Even reason for special judge Raurkela.
You have chosen Bonai.
Yes, Lordship.
And the trial court has rightly given the reason why it should not be Bonai.
Trial court has given the reason why I should not be sent to special judge Raurkela. My prayer is for send me to special judge Bonai. My
For
rival
Bonai
group-
also there is a reasoning given, sir.
Yes, Lordship, that reason is in the last page of the
Hmm.
impugned order, page number 76.
You are the gang leader, one of the gang.
This court is of the considered view that the present accused petitioner shall not be transferred from Circle Jail Sambalpur, Circle Jail Bonai, as there is a possibility of tussle between both rival groups. This is the first mistake, Your Lordship. There is no rival group in Sub Jail Bonai. My rival group is admitted fact is in Circle Jail Raurkela. And there is possibility of law and order situation and causing loss to human rights or to inmates of Sub Jail Bonai. As other accused person in the Sub Jail, same case, are detained in Sub Jail Bonai. He's saying that my group members are there. I cannot have tussle with them, Your Lordship. And 8 out of 10 are there in Sub Jail Bonai. Till now, there has been no law and order situation. Lordship, I'm not sure if there is some magical number in Indian penal system or common law penal system wherein it say 8 people is right. But once 9th member comes in, all may have.
There is a difference between a circle jail and a sub jail.
Lordship.
Circle jail has a better security arrangements.
Lordship.
In so far as the sub jails are concerned, it is a smaller jail.
Lordship.
And you are now kept in Sambalpur,
Lordship.
circle jail. Security and everything is little tougher there. So that perhaps the reason why you have been kept there. Now you are seeking transfer from Sambalpur to Bonai. Bonai is a sub jail. It is a very small jail. And looking into your background, it is not safe for the other inmate that you should be kept in the sub jail.
No, Lordship. He should have.
Basically, it's a
As
administrative.
per law, I should have been transferred.
See,
to
this is
special
not
jail
a
Raurkela.
permanent. This is not a permanent thing. They may change also.
No, they are not.
If you keep on inviting this kind of orders from the High Court and all, you will be permanently
But at the same time, my criminal defense is getting prejudiced, Your Lordship. That is why I have got an order of the Honorable Supreme Court. Lordship, and just have a look at it. This
I know.
transferring under trial prisoner to far off places.
It's not far up places. It is inside the state only.
No,
Within
200
the
kilometers
state.
away, Lordship.
200 kilometers is not far.
200 kilometers is not far.
Nowadays you can appear through VC also.
No, that is also.
And
a
we
reasoning.
have VC facility for High Court also. There are very competent lawyers.
Every single day, this person is being made to take a 400-kilometer round trip. He's being transferred from Bonai to Raurkela every single day. 400 kilometers every single day he's made to travel.
I will not interfere now. You tell me. Would you press it or hold it for some time?
Actually, then keep it pending. Let us see.
Not pending. Let us dispose it up and give liberty to approach and agent when required. At this stage, threat perception is there. Therefore, the court has rightly decided. You can later on pursue
Subject
the
Bonai, Lordship, there is no chance of person since there are no rival
The,
members. in
I
Subject
will keep it open that the jail authority will take appropriate step to transfer you at the appropriate stage if need arises. That is always kept. You can't keep permanently. So
Because they better knows how the situation.
they will assess it. They will assess it.
They
and
better
do it.
knows how what is the situation there.
Yes,
Feeling
yes.
and how
So I'll keep
somebody
it
is
open.
outside and how
It is
to
there for special jail Raurkela. I should not be transferred there because there's a rival.
I'll
there is a
keep
chance.
it open so that your doors are not closed.
Achha.
The authorities will apply their mind as and when required, and they will take a call.
Because as and when the trial is progressing, my defense is getting prejudiced.
Suppose you will be convicted, you will be sent somewhere else.
After conviction, I don't
So
have a
then-
right. But at least I have a right to defend myself.
You are
with the
conducting the
under-
earlier petition, you filed three petitions and
after
withdrawn
conviction, now I am
and
under trial.
no, I am talking
This is
about
the
the earlier
condition-
petition.
This is the conduct.
What are you doing? You are filing petition and you don't give certificates? And you filing transfer petition? What is this? Your conduct also is to be seen. Overall conduct.
In this case, I have given the certificate.
I am not talking about in this.
I
case.
understand.
What the same-
I am not
same
blaming
case.
you or your
understand.
learned friend. He might not have informed you of
He
you.
stated that he. but I-
This is the
I-
conduct.
not
They
stated.
play very smart.
I
And
bow down.
ultimately the lawyer is blamed.
I bow down.
This is what you give the judgment, I'll pass. Give the judgment. Which paragraph you can?
Paragraph 25.
25.
What copy दिला यार?
Just keep.
Oh, office number.
25.
Watch.
Soil check judgment. I was thinking of that. This judgment will not help. This judgment will not help.
So that is relied upon the constitution bench. judgment in
I
Supreme
know,
Court.
I know.
Not
I
applicable.
know this judgment, but I'll deal with it and I'll pass the order. Okay?
But some.
I'll just see.
legitimate given-
I'll not shut the door to
At least
close
in the
for all
final
time.
stages of the
What is the stage of trial?
Trial is
Three-
going on.
three
In the meantime,
witnesses.
as per a submission of my friend,
Three witnesses.
three has already been examined in the meantime. Trial is going on.
Now, how many witnesses are there?
Charge sheet copy is
47
there.
charge sheeted.
Hmm?
47 charge sheeted witnesses.
Let us see.
It's
Okay.
a serious case and locally it is.
Yes. Next.
29.
Let dispose of.
This is. But you have well done. You have well tried. Yes. Yes.
My lord, petition challenging the order of ordinance by law. It's a village dispute. Though offences are not constitutive, but in the meantime matter already been settled. All villagers are residing in their village peacefully.
What is the offense?
Offense 307 along with all other offences by law.
Who is the victim? Informant is the victim or victim is someone else?
Victim one, they have noted
You have to implead the victim
party.
as well as the informant.
I have implemented the party
Who is the party? Party means the informant.
informant. My
The victim also you have to. If he is not the victim. In
Injury is
30
kunja parida.
307,
My lord.
the person who is injured
My lord.
without his.
May I permit to implement the party?
Yes.
And
The counsel for the petitioner submits that. What happens to the earlier petition?
Earlier petition, my lord, because of a non-prosecution, earlier petition was dismissed. Thereafter.
Anyway, since you have now settled, okay.
Sorry,
Let the counsel for the petitioner submit that he has the parties to the dispute have settled and there is a out of court settlement in the instant case and full sum. He has implemented the opposite party number 2, who is the informant in this case. Since this is the case under section 307 IPC, it is necessary that the petitioner should implead the victim as well. Liberty is granted to the petitioner to implead the victim of this case as opposite party number 3. Also issue notice to the opposite party number 2 and 3. Opposite party number 2 and impleaded opposite party number 3. Returnable within 1 week. Let the amended memo parties be filed within 2 days. By Monday. Requisites also to be filed. Take it. 2 weeks. Huh? You give it on that 21st. Sorry. First February. First February. 1st February. 1st February. We don't know what this trial proceeding will not be stayed.
Not to take any procedure action.
You tell the court that now notice has been issued. Your statement is recorded. The trial court will.
that system is not mine, Lord, and claim record. No,
You are really interested to get it quashed or want an interim order through?
May I say one thing, my lord, next week, any day, they can appear directly before this honorable court.
Yes, and no, you do one thing. You appear before the IO, then let the IO confirm it. Then we will see.
My lord, according to your lordship.
By the way, what is the injury?
In simple in nature, my lord.
Simple in nature.
My lord, all the documents earlier date.
Okay, you implead, huh? Implead got it. Next,
yes.
The petitioner further submits that 29th, which is the item? 29, further submit that although the case is registered under section 307 IPC, but the injury received by the victim are simple injuries. Simple injuries. Taking into consideration the fact that the charge sheet file trial.
Whether it is simple or grievous, after getting the the injury report, I can simulate because it's a fracture injury.
Certified copy already.
No, ଆପଣ ଯୋଉଟା annexure କରିଛୁ ସେଟା fracture ଲେଖା ହେଇଛି. Fracture ଟା କେମିତି simple ହବ?
Let the IO.
Further opinion kept reserved.
Let the IO of this case file a status report regarding the fact as to whether the parties have settled the dispute amicably or not, and place the report before this court by next date. IO report. IO jayegi pachari koyo.
Let both the parties appear before the IO.
They will have. IO will call them. Report because the entire village is involved. Who knows? It's a free fight. It's a free fight. Huh.
Yes.
Yes.
Item number 30, though I have prayed for quashing. In fact, some documents need to be filed additional because I have prayed that the Migrant Labours Act will not be applicable because I have a valid license. That license I could not annex. So Lordship may kindly call it on 17. In the meantime, I'll file an affidavit.
17.
File an affidavit bringing that license on record.
No problem.
Because unless that is brought to record, I cannot seek a quashment of
yes, of course. If you have a license, then the scenario is different.
Scenario is different.
You file it.
17.
31.
Let's say praying for adjournment.
Adjourned. February.
33.
31.
31 adjourned, 32 adjourned. 33. February end. February, March. This is 5404.
5437.
33 5437. So let it go in March. Otherwise, also it should come in the March. Yes.
35.
March.
36.
36 was is 307. 307. Yes.
36.
Yes.
Item 36 is actually a Belgium matter. I was earlier on bail on single default. NBW has been issued.
Put it in the same file. Yes. Yes, sir.
OPID matter, my lord.
OPID matter. Yes. NBW.
I was on bail. Single default NBW has been issued.
Who is appearing?
In 2015, NBW was issued 8 years, and the bail order is not there. Subsequently, higher offense has been added. So earlier bail will not continue. Lordship may direct to surrender and file the fresh bail application.
Because there is a direction, I will give you hint. I was on there.
But 2015 NVW, you are coming in 2008 years thereafter.
Yes, sir, because it's full load of-
OPDI Act, you keep on collecting money from people and thereafter
Yes.
jolly well sleeping in your house. Had it been a NBW order passed, recently, I can understand. 2015, you don't bother.
Case of 2013.
When you have got the bill,
Para 2, they have mentioned 18/12/2013.
18/12?
2013.
Yes, page 12.
Page 2, para 2.
Look, a petitioner is an accused in the FIR number so and so, under section so and so. This FIR, take it up. Okay. Charge sheet is filed?
Yes.
That, the petition, FIR number, FIR dated 24/9/2013. 2013. The petitioner was enlarged on bail on 18/12/2013. Charge sheet के file है when the charge sheet was filed.
Yes, madam. Charge sheet filed on.
After investigation, charge sheet was filed on
23/11/13. 23/11/13.
23/11/13. Bail था तारा पुलिस को. Bail तो December में थी ना. हाँ. After FIR, charge sheet is filed. What are the offences added? He says in the charge sheet offences are added.
No offenses.
In FIR, Lordship may see Annexure 1, OPID Act was not there.
Yes, it is there.
No, OPDI was not there.
Page 6.
In charge sheet, it is added. And
Ah,
I have been granted bail after charge.
After charge sheet, he is.
Yes.
November charge sheet is filed.
Yes.
December,
Bail order.
18 December, bail is granted. Then you are resting. And what is the stage of trial? He is absconding.
Lord, that thereafter trial has not been continued against the special petitioner.
ମୁଁ ତ appear କରିନୁ NBW ଅଛି ତେଣୁ trial ଆଉ proceed କରିନଛୁ।
ତାପରେ the petitioner has been granted bail on 18/12/2013. Counsel for the respondent submits, opposite party submits that although the FIR was registered for having committed, for allegedly having committed the IPC offences, but in the charge sheet, OPD offences under OPDI Act, OPID Act has been added. Be that as it may, the petitioner has already been enlarged on bail after the charge sheet was filed on 18/12/2013. So, however, it appears that the petitioner has, after availing the concession of bail, the petitioner has avoided to appear in the court, leading to issuance of NBW by the order dated. Ichi file करना थी कौन करेगा?
I have given page 15 on 5/6/15. Page 15.
Nobody in the earth can read these things.
This is the certified copy I have obtained from.
How these petitions are being numbered, I don't know. Have you read it? Are you sure that NBW is issued or something else has happened?
Yes, I have.
By this order.
Hence,
I have not seen. I couldn't find NBW order here.
I'm
It is
reading.
like a doctor's prescription.
Accused is absent on repeated calls. No.
Where you are reading?
Page 15. Accused is absent
Where is page 15?
Page 15 of the brief.
This is item 36,
6.
no?
Your Lordship, may kindly see the physical brief. Accused is absent on repeated calls. No steps taken on his behalf. Hence issue NBW and put upon 20/15 for production.
तापर कौन वाला? 82, 83 proceeding कौन वाला? 2015 रू आज नहीं किसी नहीं.
How kichi he? Last order.
You have not filed up to date this thing. Have you been declared as a proclaimed offender by now or not? 8 years.
7/11/2013 को थिला for production. That certified copy I obtained a letter.
No, after see the
15 पर अब किछि है. It is just running for production. For production of the act.
Are you sure?
Yes.
No, my lord, I have
82, 83 proceeding might. Obviously, 8 hours
I have got the certified copy. Accused person is absent.
Sir, this is the last order I was talking about. Thereafter, what happened?
82, 83. All right, let him take this.
My lord.
You should come with all this thing now.
Yes, my lord. Actually, these certified copies.
ଆପଣ ଫାଇଲ କରୁଛୁ ଅନ୍ଧାରରେ ବାଡି ବୁଲୁଛି ମିଳିଗଲେ ମିଳିଗଲା ନହେଲେ ନାହିଁ ସେମିତି ଏବେ କଲେ ହବ 2015 ରେ ଆପଣଙ୍କୁ ଏନବିଡବ୍ଲ୍ୟୁ ହେଲା ପ୍ରୋସିଡିଂ ଚାଲିଛି ଲାଷ୍ଟ ପ୍ରୋସିଡିଂ ଫାଇଲ କରି ଆପଣ ଫାଇଲ କରିଦେଇଛନ୍ତି 2023 ରେ ଆପଣ ଫାଇଲ କରୁଛନ୍ତି ଏନବିଡବ୍ଲ୍ୟୁ କ୍ୟାନସେଲ କରିବା ପାଇଁ 8 ବର୍ଷ ଭିତରେ ଆପଣ ପ୍ରୋକ୍ଲେମ ଅଫେଣ୍ଡର ଡିକ୍ଲେୟାର ହେଇନାହାନ୍ତି
ହୁଏ ନାହିଁ କରୁନାହାନ୍ତି ତଳ କୋର୍ଟରେ ତାପରେ ଯଦି ମୁଁ ଆପିୟର କରିଯିବି ବେଲ ହେଇଯିବି trial will be concluded. It will facilitate in conclusion of trial. I am the only accused.
He is also not sure. At least we should know what stage it is there.
Yes, I will file that the order sheet, certified copy of.
If you make a statement, come on Monday.
Monday
I have dictated the order. That's why I am saying.
All right.
Come on Monday.
The latest order I will.
No, keep it. Type it out and keep it. Monday.
And I will make a statement whether 82, 83.
Then we will confirm this order. Okay. Okay. Monday. As Monday in the as first item, so that this order will continue. ठीक है. आपण भी ठीक देखो तू. ठीक है.
I will pardon 33 and 35.
Get जाने.
Okay. Total order court press कर.
Next week नहीं.
Urgently कर सी तो वो ओके छोटे बच्चों का.
आपण first call रे भी आसिलेनी second call रे आसिलेनी सेति भाई I put it. What are you doing? You should have told us. Why I tell you one thing. See, the case number is, I'll tell you. Case number is 33-5437 at 2023. Okay. I got a list today. The what is the first number? That in that list of cases. The one you have shown me. What is that? I was just wondering. See, the first case which is pending here is CRLMP 3 of 2023. Likewise, it is going on.
No, my humble submission.
5,000 number is listed, but 3 is not listed.
With all respect, we are filing the applications, form applications for the sake of filing. It may be also.
So what I am trying to do is, I want to get the matter listed from beginning to end.
My humble submission on behalf of bar also. I'll take some matter on mention and some matter chronological so that both purposes will solve.
That is the reason. That's the reason. What I am saying is striking a balance. The old matter should come first.
In the present case, which
it is 5,000. So you can wait.
No, here I have challenged the framing of charge. The moment charge after trial will commence, well, there will be the entire picture will infructuous. That's why, and some cases NBW, some cases other matter 311 petition. It requires a consideration instantaneously.
So can I put it on 17th, both the matters. We have adjourned it to March. Now 17th. I prepone it 17th. Today, you see, another function is there, 2-3 matters.
I'll wait. Let the list complete. I will wait time and long.
Yeah, you put it next week.
Matter is
Next,
urgent, that's why.
next week.
No, matter is urgent, that's why I have.
It's all right. Next week will not make any difference. Next week, 11th, 10th or 11th.
First case, I have challenged the order of framing of
Okay,
charge.
10th. 10th or 11th, you tell. 10th or 11th. 8th ରେ ଟିକେ ବେଶୀ ଅଛି ଆପଣ ଯଦି ଆପଣ
ଏଇଟା case ଅଛି କୋଟେ 311 କୋଟେ
already existed 9th ଠିକ ଅଛି 9th କର 9th
I'm sorry for the info.
it's all right he should have told your junior should have told I would
Sorry.
yes
କେହି ନଥିଲେ
37
ଆମେ କଣ କରିବୁ
yes
37.
So, my lord, after hearing on the court has issued a number 2, then the option number 2 has sent the candidate also was ready to appear before the court.
you are probably
And for two, I said that because this thing happened in college time and college election, all this thing happened. I'm very happy. I'm with my friends also. I have very good friends there. So one of the accused also died, and one of the accused are all the lawyers in practicing in Delhi. So I'm not interested to pursue this case also.
what is the offense
Offense is SCSP Act also. This is something happened.
there is no legal impediment
No, but in fact, my lord, there are a total 3 accused persons, my lord. Against 2 come to this honorable court, Mahanti, my lord.
has expired one of the and the remaining 2 accused being the petitioners have approached this court under section 482 CRPC seeking quashing of the criminal prosecution pending against them. The coordinate bench on 11/7/2023 directed the petitioner to serve opposite party number 2, who is the informant in this case. Land Council, where is Vokalkana? Mr. So-and-so had filed Vokalknama on behalf of opposite party number 2 and opposite party. He submits that the incident has taken place way back in the year 2015. Isn't it?
Yes, ma'am.
2015. That time, the victim as well as the accused persons were college going students. By now, by the passage of time, they become friends and they don't want to continue with this criminal prosecution. In view of the settlement between the parties and to meet the ends of justice, the FIR number so and so, the FIR number so and so, and the consequential proceeding arising thereof stands quashed. Then counsel for the state has also clearly submitted that there is no legal impediment for quashing the instant case. Yes.
38.
May it please, my lords. The petitioner seeks the indulgence of this honorable court for quashing of the entire proceeding, my lords. The opposite party number 2, being the informant, has lodged an FIR against the present petitioner under section 354, 506, 294, and 34 of IPC, my lords. Read with sections 67, 67A, and 66E of the IT Act, my lords. During the entire proceeding, my lords, they have filed one affidavit in the shape of undertaking, my lords, before the executive magistrate, that is under annexure 2, your lordship, page 13. Both of them, the petitioner as well as the opposite partner 2, stating the fact that that the matter has been amicably settled and not to harass each other in future matters. Thereafter, after the initiation of this case, my lord,
what was the allegation on facts?
Allegation, my lords, with regard to circulation of her some private photos to her family members and
blackmailing me
and
private photos,
my lord. After
videos,
my lord,
to my parents, relatives, friends. He hacked my phone number.
harassing me by calling me all the time and so such and such. In the pendency of this case, my lords, the opposite party number 2 has appeared and filed a joint affidavit before this honorable court. Your lordship.
Where?
That is flag B.
Flag
B, your lordship.
Okay.
My lords. All those things were taken on record. The order dated 49/2023.
There is an order, huh?
My lords,
Okay.
49/2023.
Uh-huh.
The joint affidavit as well as the both the parties were personally present in this court, my lord, and have deposed the same, and the personal appearance has been dispensed with, my lord. With regard to one instruction, my lord, the matter was kept further urgent. With regard to the state was asked to get an instruction with regard to the veracity of this affidavit.
Yes.
But today I have consulted the IAC, but he said nobody has appeared before him.
No, nobody was
And there
directed
no-
was to be
no
appeared.
such, no such document.
There was no direction for appearance. It was only joint
They were before, they were present before.
Copy of
this-
the same is shared on SS Pradhan to enable him to obtain instruction.
No such instruction. He's saying that I have no instruction.
They will not come and ask you for instruction. You have to go and seek instruction whether this is a court direction. You are waiting that these two people will come, we have entered into.
Yes.
No, it is contrary. The court direction, you should go verify it and tell us.
All right. We can take now on Tuesday.
May I appraise one thing, man? They were present on 49 minutes. Both the parties were present on 49 minutes before this honorable court. Their appearance has been noted down.
If the appearance is noted
My
and
lords,
everything is
my
done.
lords. The Aadhaar card or photocopies of the Aadhaar card also taken on record, my lords.
These were we youngsters.
Yes,
ma'am.
The petitioner is trial is started or
No, my lords, charges has not been submitted as of yet.
you are appearing for it. Record the appearances, all three appearances. Record the FIR number so and so under section so and so came to be registered against the petitioner at the instance of opposite party number 2. Opposite party number 2. During the stage of investigation, the petitioner and the opposite party number 2 have entered into a settlement. They filed a joint affidavit on 14/9/2023, on the basis of which jointly they have prayed for quashing of the FIR and put the dispute to quietus. The parties to the proceeding appear before this court on 14/9/2023. The coordinate bench of this court, while dealing with this matter on 14/9/2023, was pleased to record as under para 2 to 4. The matter was adjourned awaiting the instruction from the concerned IO through the additional government entity. The IO appears to have not furnished any instructions to the Learned Council for the state. Next problem. In view of the fact that the parties have already settled the dispute, filed joint application, and endorse the joint application by appearing in the court in person. Appearing this court appearing before this court on 14/9/2023 before this court. There is all there are all good reasons for quashing the FIR in subject. Accordingly, the FIR number so and so, registered before so and so, stand quashed, and the proceeding arising therefrom, the consequential proceeding, if any, arising out of the same FIR also stand quashed.
Much obliged.
Clear.
My lord, I am for the petitioner. My lord, I am seeking time next week, my lord.
Adjourn.
My lord, I have not.
Yes, 2021. 109 Act. Yes, I have a flag act. I mentioned.
You are the informant. You are the informant.
Yes.
He is the accused.
Case, code below. And here.
What is the check amount?
1,70,000. And yes, is a flag end. Well, already.
What do you want in this petition? This flag and so then
My lord, may I pray?
go and get in conviction against him.
My lord,
I have the complainant. He is the accused.
I am.
That's what I'm saying. It is whose petition?
I am the petitioner.
There is no stay.
Yes.
No, my lord, there is stay, my lord. I have not collected some relevant judgments, my lord. So may I pray kindly take on next week any date, my lord.
So you have obtained stay when you obtained stay?
25/8.
25/8, my lord. 2023, my lord. 25/8/2023. I'm seeking only.
What is the stage of stay?
Already completed. Only argument stage also. Case,
No, my lord.
because defense and petitioner already examined.
What do you want?
My
What
lord, case is
argument.
for defense evidence.
Defense evidence already completed. And it is 7/7/2023.
7/7/2003.
Thereafter, when I'm
this matter was filed when? August.
matter was
And you
filed
got a stay on. What is your case on merit?
My lord, the fact of the case is that the present petitioner and the accused both are doing job there in one place, my lord. Thereafter, my lord, prior to issuance of the check, the present petitioner has lodged one FIR before the local PS that my check has been misplaced somewhere. So in this regard, the concerned PS, my lord, investigated into the matter, my lord. Thereafter, the complainant, opposite party, my lord, he has deposited some, I have issued 3 number of checks, my lord. Total amounting to rupees 1,72,000, my lord. Thereafter, when I asked the complainant, you don't deposit, but he has deposit, my lord, the opposite party. So that is the backdrop of the case, my lord. Both are.
You once the statutory notice was issued to you.
My lord, the
have you told all these things?
Yes,
Statutory
yes.
notice.
Yes, my lord.
Just show me the statutory notice.
Statutory notice was served on my lord.
Hmm.
The petition to the opposite party, it revealed that the alleged check was issued by the present petition to the opposite party on my lord 2/9/2021 and 7/9/2021. But prior to lodging of the complaint, the present petition had already intimated to the bank as well as the local police about the missing of the check, my lord. For that reason, the bank intimated to the complainant that.
You are reading the reply.
No, my lord. I am reading.
Statutory notice reply. Have you given the reply?
In this regard, I have collected some judgments.
What judgment?
Next week I will satisfy the lordship.
I'll tell you in 138 proceeding, if you are saying that your check was stolen and the stolen check was presented, no, you might have received the statutory notice. What is the idea of statutory notice? You have to at the very threshold you have to say that these are the checks stolen from me or I missed it. And you have presented. If you don't reply to the statutory notice, you don't have a case.
My lord,
the presumption operate against you under 139.
My lord, Monday your lordship fix, my lord. I will satisfy.
Now what I'll do is I'll fix in the end of this month. No problem. But I will vacate the
Monday. I will satisfy.
Listen, I will vacate the interim order to the extent that let the trial proceed. No final.
Kindly pass over. I will call my senior.
No. I only what I'm only saying is
Your lordship.
it will not prejudice you. I'll tell you why. No the final order will not be pronounced by the trial court, but trial will proceed. So that time is not wasted.
One password.
This is the last matter, what password? Anyway, one password, let it see. Yes.
But the previous circumstance will matter to settle the right, village rivalry, and the last occasion, my lord has called for the
There is a problem here. Whether a trial is going on and the injured has deposed, but and examination in chief, page 39. Padmalochan.
Padmalochan is the injured.
Yes, he has stated.
Sagar Sahu is the informant.
I sustained fracture injury on right hand arm. I was wearing full shirt at the time of occurrence.
You have settled with the informant or the victim?
informant and injured already, both are filed there.
In the Padmalochan,
Hadibandhu is there, and see the last page, 58.
Then Padmalochan would have done affidavit.
Padmalochan is not there.
I say, Lekiji mo.
Yeah, my lord, can you see the doctor? And Hadibandhu is
I sustained fracture injury.
on the FIR allegation. On FIR allegation, Padmalochan was here. But when can you see the
Who is the victim?
victim?
Injured.
Injured, I have examined Hadibandhu sir. Page 56 में can you see? Evidence of the PW 8. Injured.
Padmalochan.
No, Hadibandhu.
No, actually.
Padmalochan also filed affidavit. Hadibandhu also filed affidavit. Sagar sir also filed affidavit.
Padmalochan
also filed affidavit. My Lawrence friend has filed all three.
Doctor's evidence.
Doctor's report on 56.
No, ये इठी डिपोज कर साला पर इठी एफिडेविट केमी दबो कंप्रोमाइज करिया में.
He's saying something in the court.
No.
Midst of the trial, he deposed against the accused persons. Now he come up during course of trial. He come up. No. से को थोड़ा भूल लेगा थोड़ा ठीक.
It is acquittal.
What acquittal?
ये जो उटा देइछन्ते आपण पेज 43 आपण नीचे देखंतु.
It is evidence.
पद्मलोचन रो पेज
Acquittal कोन कोडे acquittal कोन?
One of the accused has been got acquittal placing on the compromise. And this is the order of my last occasion, my honorable court sought for report from the current trial judge. That is in the report.
ସେଇଟା ଦେଖି ଦିଅନ୍ତୁ ନା ସେଇଠି ଆମ ପାଖରେ କିଛି ଆଉ ନାହିଁ.
I said that
Where is
report
that?
kindly see.
Where is
Flag
it?
B.
Hmm?
On flag B, that report may kindly see.
ସେଇଟା ଦେଖି ଦିଅନ୍ତୁ.
B for Bombay. B for Bombay.
Yes, ma'am.
E. Yes. There are some orders in your past. Yes. Even first order. Yes, come to the first order. Yes. According to the Council, the petitioner co-accused persons having faced the trial of once having been acquitted pursuant to the judgment passed by Sessions Court also a scene for
Like after. Without a form.
To the FIR story as well as relevant recorded it to the police and station the state witnesses have also not mental discredited in any manner in the course of their prosecution. However, subsequently they have been required to report the concessions to verify the federal please report. This court with regard to the circumstances the refund has been allowed and steps taken by the court into sentencing of the witnesses. No cross-section shall be taken. What is this recall business?
Yeah, after the occurrence, some of the accused persons have been given evidence, three proceedings noted. Thereafter, compromise held between villagers within with the presence of the serpent. And thereafter, they are recalled. Kindly see, my learned friend is reading last para kindly see.
recalled and in the, on the recall petition, they have stated that I have, matter has been settled, we have there was no enmity between the parties, and therefore, basing on this report, the acquittal order under Annex 2 will. One of the, who accused has been got acquitted. Annex 2, the base 33 kind is separating part.
2/1/2023.
Yes, sir.
Justice R.K. Patnaik's order.
No. That is the separate case. The separate case, no. That is, I filed the another cognizance order in basing on that is the accused person that got bail. Honorable R.K. I cannot take bail.
Which one then?
Where I have mentioned in the first title 3756 of 2020. Criminal misdeeds.
3756, flag E, flag E, Your Lordship.
Flag E, which page? I am not able to find out what.
Misplaced.
Flag E is all right. This is the status of the case.
No, should not. Flag E ta hochi 3756 of CRLMC, 3756 of 2022.
Yes. 3756.
Yes.
There, the orders are there.
Yes.
Which order you are referring to? 2/1/2023, Justice R.K. Patnaik. He says that it is something else. Thereafter, another order. Thereafter, 4029, Justice Chittaranjan Das order. Which one you are referring to?
My lord, I am referring the present case, not in this case.
You said flag E. I am
No,
looking at flag E.
First case, flag E ta first case file kortele. Seta kon dispose hoipi before Your Lordship, that is the order might be there. I don't know.
What are you referring to now?
My lord, last petition, my lord, kindly see the.
Which order? Which order you are talking
My
about?
lord,
512.
No. This honorable court order 512. Kindly see.
Yes, that's what you tell me.
Yes, 512.
Yes.
My lord had called for
Which,
report from the law.
which paragraph?
4 paragraph.
Huh?
Paragraph 4.
However, subsequently they have been required to recall.
Yes.
Clarence Sessions says Niagara to verify the record in the said ST and place a report before this court with regard to the circumstances on which the recall has been allowed and the steps taken by the court on the interaction of the witnesses.
Yes, that report has been called.
Where is that
Report
report?
there.
Where is that report?
That is flag F.
Flag F.
F. Frog. F.
Yes. What does it say?
Say reporter.
Yes, now.
So F. Say reporter.
No, সেটা নেই। সেটা নেই। This is the current what will last paragraph.
I was looking at yes. 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 What do you want to show from here?
Yes. One of the accused persons have been acquitted.
Where you show me where you want to read.
Annex 2 million. Annex 1 is the affair. Annex 2 is the order. Page 33 kind of operating part.
Page 33 of this report.
No, this petition. The report is there. Report is there.
You are showing report. I am going to 33.
No. Verify the report below first.
What does the report says? You kindly
That report is there.
What is this report saying?
Report saying that
Let us go to report first. Read the report. So let us read the report. Do you have the copy?
No, I have not copy.
Let us read the. Let us read. What does it say? Give a copy to him.
No. I list last para. I have already gone through.
Then you said, what does it say? You tell me.
This matter has been settled and the on the recall position.
Last paragraph, last paragraph.
Last paragraph.
It is apparent from the evidence of the informant that after the examination of PW so and so, 3 PWs,
Yes.
the matter of dispute has been settled in between the parties
Yes.
at their level. So the information did not tell anything about the occurrence. Subsequently, PW 1, 2, and 3 also deposed in favor of defense on recall.
Yes.
The informant and the injured persons and his family members have not supported the case, and the prosecution neither challenged the order dated 20th April 2023 passed by the trial court allowing the recall petition, nor proved the case against the accused persons beyond all reasonable doubt, for which the accused person held not guilty for the offense. Who is this accused person out of?
One accused persons.
How many accused persons are there total?
Total 7 accused persons.
Against which accused person?
This is the Ganesh sir. Ganesh. No, I am for the other person. All.
Ganesh.
Rest of them.
Ganesh.
Ganesh is acquitted.
Yes.
Unacceptable.
That acquittal order is at page 13.
Page 13. Unacceptable. Okay. And operating party is unacceptable.
The trial was going on simultaneously together. Why Ganesh is separated?
Ganesh separated.
Why?
Because he was apprehended.
You people were absconding.
No. I am on a bail. Thereafter, subsequent. He first arrested and charge framed against him, and he faced trial.
Your trial is segregated. That's what you mean to say. How many of you were segregated?
6%.
6% segregated. And the deposition which he is relying is in your case or that Ganesh case?
Yes,
Ganesh case. Ganesh case. What happened to their case?
Then they have not initiated. Charge has not been taken. Only cognizance has taken.
You are on bail.
Yeah, on bail. Yes.
That's what he's trying to say is, now I understood what he's trying to say. You are saying one sentence and going to some other sentence. You are arguing in the High Court means you should have some clarity. What he intend to say is, there are many accused. How many of you are there? 7 accused.
Total 7.
One of the accused, Ganesh, was apprehended, put to trial. Witnesses came, deposed against him. Thereafter, these people were apprehended. Their trial were segregated. Trial is going on at the very threshold.
Yes.
What had happened is these witnesses, 3 witnesses deposed against Ganesh. After deposition, they enter into settlement. And surprisingly, on whose application, either your application or their application, they were recalled.
Yes.
They were recalled.
Yes.
The witnesses were recalled. Once they recalled, they say that we don't support the prosecution. They went by the settlement. On the basis of that, Ganesh was acquitted. Now these people have at this stage filed this petition to say that since Ganesh is acquitted, the settlement is confirmed and joint affidavit is filed, give that benefit to us. That's the whole long and short.
Yes,
of it.
exactly. Total.
He's taking throughout world to come. Sometimes this point, I am not able to understand Ganesh. Who is Ganesh? What do you say? What do you say? Sure. What is the number?
Rest 6 are before your lordship.
What is the number? 402.
367A. 367 Your case now 367.
Your case is 367
A.
A. And Ganesh case is
367.
There are 8 accused.
7 accused. Here 6.
6.
Ganesh is 7.
Okay. On the basis of FIR number so and so dated 9/6/2022 under section, all the section you write down. The criminal law was set into motion against 7 accused persons. Good, sir. The present petition is filed by 6 accused persons out of the total 7. These petitioners have successfully avoided the police and remain uncooperative. However, one of the accused, namely Ganesh, Purana account Ganesh,
Gani alias Ganesh.
Gani and Ganesh was apprehended after charge sheet was filed. He was subjected to trial under ST case number
282 of 2022. 282 of 2022.
ST case number
Annexure page 13.
ST case number 367 bracket A of 2022.
367 ଟା ଆପଣଙ୍କର
ଆପଣ 367 ନା 367A?
367 is the GR case.
GR case, I am talking about GR case.
GR case 360.
ଆପଣଙ୍କର ନା ଗଣେଶର?
Gणेश 367.
ଖାଲି 367 GR case, ST case number 367 of 2022. ST case लिखा है
ST case number 282.
And see the order says, by means of the present application, the petitioner seeks indulgence of this court to quash the further proceeding in connection with the ST case number 367 capital A of 2022 in your case. And what about the ST case number in Ganesh case?
282. Page 13.
Page
13.
13. ST case number 282. 282. कौन लिख लो? of 2022. ठीक है. 3 witnesses, namely PW1, 2, and 3, were examined. All the witnesses supported the prosecution at the initial stage. However, after deposing before the court, the accused persons appears to have settled the dispute amicably. Panchayat re?
Yes, sir.
Amicably in the village, before the village panchayat. Therefore, the said witnesses filed affidavit inter alia stating that they have settled the dispute and they have no grievance against the accused person. At that stage, the petitioner, the witnesses were recalled at the instance of accused
Ganesh Behra.
Accused Ganesh Behra.
Yes.
Accused Ganesh Behra. Full stop. On recall, the said witnesses have wriggled out of their earlier statement and reaffirmed the fact that they have settled the dispute. Full stop. On the basis of the said
Evidence
statement by the witnesses, the learned assistant sessions judge Nagar, women's court Nagar, recorded a wide order dated 8/5/2023, recorded an acquittal order in favor of the accused Ganesh
Behra.
Accused Ganesh Behra. Next problem. ଆପଣଙ୍କୁ ବେଲ୍ ମିଳିଲା କେବେ ସରେଣ୍ଡର କଲେ?
At the stage of cognizance, two persons have already granted well, thereafter.
କେବେ କୁହନ୍ତୁ? Next problem. Petitioners were subsequently apprehended and they were admitted to bail on different dates. After the charge evidence chalchi
No.
how
After the-
cognizance the Learned Trial Court took cognizance of the offence against the accused persons, namely the petitioners. Full stop. At this stage, and they are put to trial in ST case number.
No ST case now, only GR case. They have not.
It's the ST case lekha hai. How are you saying? I don't know. Justice Chittaranjan Das order indicates a ST case number 367 capital A of 2022.
Sorry.
What is that case?
Actual set
That is GR case now.
yes,
That is wrong, and
Yeah.
it's not ST.
not test.
ST not now.
You should have moved an application for correction. What is this? Not in GR case number. In the end, it is written no coercive action in GR case.
Yes.
GR case number 367 of 2020. The next problem. The matter was taken up for hearing on 5/12/2023 by the coordinate bench and has been pleased to pass the following order. Para 3 to 6. Para 3 to 6. Yes, pursuant to the aforementioned order, the Learned Sessions Court, District and Sessions Court, Nayagarh, filed a report dated 2/1/2024, inter alia mentioning as under relevant part is reproduced. Para 3 এটা নিয়ে দিব, এটি হচ্ছে last sessions court last হচ্ছে এটা flag e তলে আছে flag f, this is flag f. Para last paragraph, it is apparent, write down, it is apparent last trial court, apparent they said last trial. The where is the joint affidavit?
No joint affidavit. Informant and two persons injured are filed affidavit.
Where is that? Flag?
Flag. Amul ଦେଇଛନ୍ତି.
Is there in that?
Amul ଦେଇଛନ୍ତି.
Where? Here. Just show me. Where is that? BCD nahi bhai. BCD. Ye this one. Haribundu se, the Haribundu Sahu is injured. And Haribundu and
Sagara is the informant.
Padamalochana.
And Sagara is an informant.
The informant, namely opposite party number 2, Sagar Sahu, along with two injured witnesses, namely Haribundu Sahu and Padmalochan Sahu, have filed affidavit before this court, reiterating their stand that they have settled their dispute with the accused persons alike, alike the other accused, namely Ganesh Behra. Ganesh Behra. On the strength of the aforementioned facts and documents on record, the petitioners are seeking indulgence of this court by invoking section 482 CRPC, invoking jurisdiction of this court under section 482 CR. Having taken into consideration the entirety of the facts and circumstances of the case, this is a fit case to invoke the jurisdiction, inherent jurisdiction of this court, and accordingly, I feel it appropriate to quash the FIR number so and so, and consequential proceeding arising thereof. Petition is allowed. Yes. While submitting, at least get some clarity so that we can save time. This could have been done within minutes. ଆପଣ କଥା ଭାବନ୍ତୁ, ଆପଣ ପଢିକି ଆସୁଛନ୍ତି, ଆମେ ତ ସବୁ ଯାକ ପଢିପାରୁନୁ ନା, ପସିବଲ ନାହିଁ। ତେଣୁକରି ଆପଣ ପଢୁଛନ୍ତି, ଆପଣ ଭାବୁଛନ୍ତି ମୁଁ ଯୋଉଟା ଜାଣିଛି କୋର୍ଟ ବି ଜାଣିଥିବ, ସେମିତି ତ ହବନି ନା। କୋର୍ଟ ପଢିଲା ପରେ ଜାଣିବ। ଆପଣଙ୍କୁ ରେଲେଭେଣ୍ଟ ପେପର ପେଜେସ ଦେଖେଇଲେ ଇମିଡିଏଟଲି ହେଇଯିବ କାମ। Anyway,
pardon to make a mention, which is a urgent matter.
Yes.
The warrant will be issued on 8th, my lords. The warrant will be issued on 8th January.
Will be issued.
Yes, my lord.
Have you spoken to the judge? Have you spoken to the judge?
No, my lord. What are the instructions?
Then how do you know? Warrant will be issued.
Already issued. No.
You are sure?
My lord, what about the instruction actually?
If you are so sure, what is the? You don't need court's intelligence. You have other sources also.
No, my lord. Actually,
how do you know while making a submission? Being a young lawyer, you should be very careful about your words. Will be issued means what? You are you know either the insider story of the judges or something else.
8 is fixed for the hearing. So unless the bail is granted by this honorable court, there is a possibility.
This is not a bail court. This is not a bail court. Again, this is not a bail court. This is a 482 court.
Not an interim protection only.
No interim protection. This is not at all a bail court. Not at all a bail court. You will not get anything out of it. If you have come for quashing, if you have a good case for quashing, I will interfere.
So, my lord, kindly list this matter on 8th minutes.
February.
Where the petitioner.
What is the number of your case?
5301, my lord.
February.
Where the petitioner is a naval officer, so it is the false case has been forged against him. So that's why that is the.
Maybe false case. Anticipatory bail you await might have been dismissed. Definitely.
No, my lord.
Go to anticipatory bail court. 438. Who stops you? Who stops you? Go to 438 court and get it. If you have a good case, we will quash it subsequently.
Yes, my lord. But there is some.
Choose the right word. And every sentence you spoke against your client.
He is having no words to say. Mom,
he started saying wrong things. Anyway, we'll see what to do. Yes.
And what I'm saying, kindly see page 26. If he praise the application, that goes against you. Why? The address of the petitioner is Jaspur. Check of the Jaspur. Justify a fabricated document. I have lost the affair after 8 months of the occurrence at the Jharkhand. That is the observation of the learned court below. That unnecessary, if you check up the record. What I pray, my lord, if the lordship issue notice to this document filed by the petitioner, that it goes against him. Because This is the observation of.
I know, I understood what you are saying.
After 8 months.
But the
At Jharkhand.
see his problem is
He is the
unnecessary.
main council.
We'll put it in next week.
Monday row. Monday row.
Next week, isn't it?
Monday busy, huh? Monday both matter.
Tuesday row. So he pray for the Monday.
11th. 11th.
Last chance. On that day he should argue because.
Only today, my lord, taking time.
Richard Likidevo, 39 re. The Land Council for the petitioner seeks adjournment. However, the Land Council for the petitioner opposes the adjournment on the ground that the petitioner has availed interim order from this court on 25/8/2023. Therefore, he wants to prolong the proceeding. In view of the same, the matter is adjourned to 11th. It is made clear that no further adjournment will be given on that day.
If he prays, then
11th, no further adjournment.
No, that is correct. But a document filed by the counsel for the petitioner is a fabricated document. If Lordship issue notice, then he will be in trouble.
You just see, better you withdraw.
This is the observation of the learned court will also. Resident of Jaspur, permanent address Jaspur, temporary address Jaspur, check of Jaspur, bounce at Jaspur. He filed a document after 8 months. The law is Jharkhand. It's totally fabricated. Their signature put in Hindi.
Because,
in petition is in English. This is completely.
And this is the defense he is using in 138.
Yes.
Entry mode to continue.
Entry mode will continue.
Your Lordship dictates that the counsel for the petitioner objected. It's a wrongly your Lordship dictated. Counsel for the opposite party objected.
No, reversing.
Sir,
He opposite party is taking time and petitioner is objecting.
No.
Yes.
Petitioner taking time.
Petitioner is taking time, opposite party is
yes.
objecting. Sorry. Stay to thank you. Okay, thank you.